morning, everyone. Welcome to the second day of our fall argument session here in Philadelphia. As you may know, because I say it all the time, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and the Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. Last year, we celebrated our court's historic 300th anniversary here in Philadelphia. We are privileged to sit in three historic courtrooms: Harrisburg, Pittsburgh, and Philadelphia. Here in City Hall in Philadelphia, the facade of our bench is constructed of beautiful Mexican onyx, with each of the 7 panels divided by bronze statuary representing the Greek figures of law, justice, and jurisprudence. To the right of the bench is an Italian marble bust of John Bannister Gibson, Chief Justice of Pennsylvania from 1827 to 1851. To the left of the bench is a bronze bust of George Sharswood, Chief Justice of Pennsylvania from 1879 to 1882. Chief Justice Sharswood was a well-respected member of the Philadelphia Bar. Directly behind our bench is a mural completed in 2002 by 2 local artists, Michael Webb and Max Mason. The view is of Independence Hall, of its southern facade, with the historic Pennsylvania Supreme Court courtroom to the left. The interior of both the courtroom and the Justices' Conference Room were designed by George Herzog. While you are here, I hope you will take a moment to observe the majesty of our courtroom and its tributes to our system of justice. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by stating your name and the party you represent, and by introducing your co-counsel to the court. The justices are familiar with the cases, so I ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. I also remind you that we do not permit rebuttal. In cases in which there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they are asking you a question, although they may interrupt you. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues that we want to explore further. While there is no time limit for argument before our court, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Stanley Crawford et al., Applts versus Commonwealth of Pennsylvania et al., representing Applts. Ms. Kazmi Ahuja, representing the General Assembly. Mr. Thomas Collins, representing Senator Keith Ward. Mr. Anthony Holzman, representing the Commonwealth. Mr. Daniel Mullen.
Good morning.
Good morning, Your Honors.
In this case, the City of Philadelphia and certain individuals brought a declaratory judgment action against the Commonwealth, the General Assembly, and certain members of the General Assembly. They challenged the validity of 2 Pennsylvania statutes limiting the local regulation of firearms. We address whether these statutes preempt the field of local firearm regulation, constitute a state-created danger, deny the right of substantive due process to enjoy and defend life and liberty under Article 1, Section 1 of the Pennsylvania Constitution, or interfere with the delegation of public health responsibilities to the City of Philadelphia. Please proceed.
Good morning, and may it please the court, before I begin, I'd like to introduce my co-counsel, Ben Geffen, here with the Public Interest Law Center, and Lydia First with the City Law Department.
Thank you.
I am Jasmeet Ahuja, pro bono counsel for the City of Philadelphia, Ceasefire, PA, and 10 residents of Philadelphia and Pittsburgh who have lost their children, their siblings, and their loved ones to gun violence. Appellants have brought the case before you because they are facing a public health crisis of staggering proportions. Black and Hispanic Pennsylvanians living in poor, segregated communities like Strawberry Mansion here in Philadelphia and Homewood in Pittsburgh are being shot and killed every day. Survivors, some of whom have joined us in the courtroom today, are left to struggle with the unrelenting grief and constant fear for their lives and the lives of their loved ones. All we ask is our day in court to prove Aplt's role in this epidemic. The affirmative actions in enacting, maintaining, and expanding the firearm preemption laws are unconscionable and unconstitutional. They violate the government's duty, as this court said in Robinson Township, to refrain from unduly infringing upon or violating constitutional rights, including by legislative enactment. In this case, Aplts have violated Article 1, Section 1 rights to enjoy and defend life and liberty.
Counsel, fundamentally, I think you have to persuade us that this is not a policy call that is truly in the responsibility realm of the General Assembly.
Your Honor, this is not a policy issue before you. It's a constitutional issue. It's a constitutional issue as to whether these firearm preemption statutes and whether the actions of Aplts violate appellants' constitutional rights under Article 1, Section 1. These are substantive due process rights.
Counsel, let's discuss that substantive due process. Your basis is that, I believe your language is that a right to self-defense by legislation?
Your Honor, that is one way to think about it, self-defense by legislation. As you know, this city has a profound history of regulating firearms. Starting in 1790, there was an ordinance on the book that in order to discharge a weapon in any form, you had to get permission.
Share with us how a collective right exists in the Pennsylvania Constitution, which is an individual right to self-defense. Where is this unenumerated right of collective legislation?
Your Honor, you can call it a collective right or you can call it an individual right. We see it as both. The right to self-defense is not limited to a right to bear arms. The right to self-defense is broader. It encompasses the right to ensure that you can protect yourselves, as Philadelphians have done for centuries.
Why isn't that a call for the General Assembly to make? Why isn't the argument you're making one that belongs to the elected senators and representatives from the city of Philadelphia and the General Assembly?
Your Honor, they have gone before the General Assembly for decades. That is part of our argument. They have gone before them and sought to vindicate their constitutional rights. They see every day on the streets, we all can take judicial notice, of the individuals who are dying. They're prisoners.
We're the backstop. We're like the second choice then. You want us as sort of the on-deck batter if there's a strikeout with the legislative branch, you'll come to us for a different policy judgment?
Your Honor, we assume that the General Assembly does not intend to violate the Constitution. That is their requirement. But when they do, it is the prerogative and duty of this court to vindicate those rights, as you've done in the past.
How are they violating the Constitution?
Certainly. People are dying every day, Your Honor.
How is the General Assembly violating the Constitution specifically?
Your Honor, we have brought two claims. We brought a substantive due process claim straight under Article 1, Section 1, and we brought a state-created danger claim. Article 1, Section 1, what you're supposed to do here is, because we're talking about fundamental rights, and the plurality did not consider that, we can discuss that in a moment, but because we're talking about fundamental rights, the statute is required, it is necessary to ensure that it is promoting a compelling state interest, and that the enactment of the statute is actually promoting that interest, that it's narrowly tailored to that interest.
Does that mean that if we grant you relief in this case, we're going to be available to adjudicate anyone's claim that somehow their rights to life and liberty are impinged by some policy judgment the General Assembly has made? Where does this end? Is the next case somebody coming in and saying, you know, we have a drug epidemic, the legislature hasn't done anything, please issue some decree, or hunger, or some other social ill? We have a lot of social ills, as we all know, and they're not getting any better. So if we grant your relief, where's the stopping point for this court inserting itself into policy decisions that we elect the legislators to make?
Your Honor, I'm glad you asked that question. Let me be very clear. We are not asking this court to invent a new standard. On the contrary, we are asking this court to apply the tried and true standard of judicial scrutiny when it comes to statutes, ensuring that there is, in the case of fundamental rights, a narrow tailoring of the statute. When it comes to state-created danger, we know the requirements of state-created danger. There are 4 requirements, and we have alleged proof to meet those requirements to survive.
Has that ever been used to strike down a statute of general application?
Your Honor, as the court said in Johnson, it has not. But let me be clear. There's never been a claim brought under the Education Clause until one had in William Penn. There was never a claim under the Environmental Rights Amendment.
That's actually not true. There was litigation over the Education Clause prior to William Penn. There was litigation over the Environmental Rights Amendment prior to the PEDF case. So those weren't new claims. It just so happened that the court took a different direction than the court had previously taken on those claims.
Your Honor, there's no principled reason to immunize legislation from substantive due process rights. On the contrary.
Isn't there a principled distinction between the Environmental Rights Amendment cases and William Penn's school district case on the one hand and your case here? Didn't those cases involve specifically enumerated rights under our state constitution, expressly enumerated rights under our state constitution, compared to your somewhat inchoate claim about alleged substantive due process rights, words that don't appear in our Constitution, by the way?
And we're not asking you to veer far from the Constitution, Your Honor. We're asking you to look at Article 1, Section 1, the right to enjoy and defend life and liberty. There can be no other right to liberty than being a prisoner in your home.
Well, what's this trial going to look like if we allow you to go there? Because to Justice Weck's point, let's assume you can try to argue or prove that somehow, some way, the FPLs violate life and liberty, or the legislature's refusal to revoke the FPLs, or the legislature's refusal to enact more gun ordinances violates the FPLs, and you're saying that that's going to be life and liberty. I assume that the other side is going to present about a lot of evidence that points out how further restrictions of lawful gun ordinance will violate life and liberty, how the Pennsylvania Constitution guarantees not only life and liberty in defending it, but to use firearms to defend oneself. And they're going to argue that our actions are very consistent with life and liberty. Aren't you putting the court in the middle of deciding the very policy question of, is more gun regulation better for life and liberty, or is less gun regulation better for life and liberty?
Your Honor, let me be very clear here. We are not asking for any infringing upon the Second Amendment right.
I'm asking you what your claim is, what the General Assembly is doing, and again, I'm not sure whether you're doing a facial challenge to the FPLs or an as applied, or you're challenging their specific failure. I don't know what you're doing, but on the life and liberty thing, you want a trial where you're going to present evidence about how these FPLs are harming life and liberty, right?
Yes, Your Honor. We presented pages and pages and pages of evidence.
And they're going to present evidence at trial on why they believe further restrictions on lawful gun ownership are going to violate life and liberty, and you're going to ask a judge to decide who wins.
Your Honor, the ordinances we proposed, the 3 proposed ordinances that we include in our petition for review, very much target unlawful ownership. And they're existing on the books in multiple states across the country. Some have even been upheld post-Bruin, and they are currently being challenged. But there is no question that we are trying to target unlawful ownership. We are trying to target all of the guns that exist in Philadelphia and get them off the street. We are not trying to impinge upon lawful ownership. If I choose to get a weapon tomorrow, they'll check my background on the permanent purchase. I'll wait 30 days, and I will get my weapon. But if I have a history, as Representative Sirica talked about the General Assembly regarding the permit-to-purchase ordinance at issue, and he was concerned about preemption, the permit-to-purchase ordinance targets those who should not because they're unlawful. They're trying to traffic in firearms. That is what we're trying to target, Your Honor.
Counsel, you're challenging the General Assembly for the safety of Philadelphia. My concern is, do you not have the incorrect party? Would not the appropriate focus be on the executive or the lead chief law enforcement officer of Philadelphia to engage and proceed with prosecution for those who have committed these offenses? I, as the lone Philadelphian on this bench, more than anyone growing up in South Philadelphia, I too have witnessed this type of violence. But the concern that I have, it appears to me you've sued the wrong party. I'd like to know one of 2 things. What is the affirmative act that the General Assembly has done pursuant to your state danger theory, and compare that to the affirmative act of possibly the prosecution withdrawing prosecution each and every day in our courtrooms with regard to crime central to Philadelphia? So share with me, where is the affirmative act of the General Assembly in comparison to the affirmative act of withdrawing prosecution, such that we have a correct party before us?
Thank you, Your Honor. I believe you're talking about the activities of our district attorney here, and I would be happy to address that. The difference between the activities of the district attorney and prosecuting or not is about punishment. We are talking about prevention. We are talking about ensuring that an individual can't buy 10 assault weapons and then traffic it.
Counsel, punishment or preventive, it saves our lives, and we may not have family members sitting in our courtroom who lost people because of a criminal act. So the question I have is, I got the policy decision. I'm asking you, what is the affirmative act? Distinguish what you're claiming the affirmative act of the General Assembly is compared to the executive branch, a.k.a. our chief law enforcement officer.
Certainly. So again, I am focused on prevention, not punishment. So the affirmative act is the enactment of the laws, the continuing to maintain them. When bills are proceeding in the House to perhaps repeal or narrow the preemption statutes, they're sent to committee to die. I'm talking about those affirmative acts on a daily basis. And with respect,
excuse me,
yes,
isn't the remedy, given that everything you say may be true, isn't the remedy under our system of democracy to elect different lawmakers, to vote the people who aren't doing the job you want to see done, to vote them out of office and elect new lawmakers? I don't see under our system how the court can remedy something that is already provided for in our democratic system through elections.
Your Honor, the remedy is also a constitutional remedy. As this court has found in other cases, when a particular legislation violates the Constitution, it is incumbent upon this court to provide that remedy. Yes, we have elected new different members. We have tried, we have had vigils, protests, colloquies on the floor of the General Assembly. Unfortunately, that has made no difference because they have decided that this purpose of uniformity matters more than individuals dying in Philadelphia and Pittsburgh.
To make that policy decision. I'm still not getting from all your briefing and all your arguments how we get to tell the General Assembly that they made the wrong policy decision, whether it's a policy decision to, I guess in your argument, privilege the right to bear arms over the Article 1, Section 1 right, or to privilege the statewide uniformity interest over counties making their own ordinances. It seems like should we grant you relief, we're creating a forum where a trial would occur that would look a lot like a debate is supposed to be on the General Assembly floor, right? Because arguments would be made in the trial court, I suppose, about the different weights and interests to be given to different policies, so that the trial judge or the jury in such a case, or would be a trial judge, I guess, Commonwealth court, would then be just imposing his or her own policy judgment. So you'd have one person's policy over the policy of the entire General Assembly. It's just turtles all the way down. Can you respond to that?
Absolutely. This is not a policy judgment. This is about lost lives. This is about the inability to leave your home. This is about your fundamental rights under Article 1, Section 1 of the Constitution. It is like a war zone in some parts of Philadelphia. Children are afraid to leave their home to go to the bus stop, to go to milk. Ms. Pichardo is afraid to leave her home to visit her family in Germantown because that is where her sister was murdered. This is about the fundamental.
That's a compelling jury argument. That's a compelling policy argument. That's a compelling argument to your lawmakers and on the General Assembly floor. But it doesn't sound to me like a concretized constitutional argument for a court. I mean, it sounds like slogans, and I don't mean that pejoratively. It seems like slogans that are properly addressed in a policy forum, not in a courtroom.
Your Honor, let me put it this way to you as a hypothetical. Imagine that the motor vehicle regime was equally bare bones, okay? We had a registration, we had an age requirement, but that was it. There was no driver's license test, no eye exams, no stoplights, no stop signs, no speed limits, okay? And then here in Philadelphia,
Sounds like Texas.
perhaps, here in Philadelphia, at a particular intersection, let's say in South Broad, there were accidents happening on a daily basis. Residents would go to the General Assembly saying, please, can I please have a stop sign? And they were told for decades, no stop sign for you, no stop sign for you. And as a consequence, thousands of individuals were killed. Hundreds of children were killed. We are asking to not get in the way. In the grandmother's sort of preemption scheme, there was a balance between those state and local governments trying to work in a coordinated fashion to ensure that an objective wasn't lost. Take air traffic control. That makes sense. You need to have one entity governing. But here, there's no coordination. Frankly, it's a stunning abuse of power that the General Assembly has said, no, you cannot regulate, and we're not going to do anything else. We're going to stop every bill you try to pass. We're going to ignore your constitutional rights, even if you're afraid to leave your home. Your Honor, Article 1, Section 1 has to mean something.
Well, maybe Article 1, Section 1 means that the General Assembly has decided that they've gone about as far as they want to go at this point in time, because to do so would hamper the ability of people to use their right to bear arms in defense of themselves. I mean, again, you're falling back into this policy argument, and I sort of agree with Justice Weck. You're making very compelling arguments, and I'm not going to diminish at all the pain that people have suffered due to gun violence in Pennsylvania, let alone the pain that people have suffered due to DUI, the pain that people have suffered due to drugs, the pain that people have suffered due to all the, as Justice Weck rightly said, all the ills of society. The problem is your whole argument is built around emotional rhetoric. And the Constitution has to be grounded in the text of the Constitution and the separation of powers. And, particularly, I thought you said they have chosen consistency over people dying. That's rhetoric. It's harsh. They would say they have chosen the idea of having a uniform area of laws so people can predict how to defend themselves. They're not diminishing what is happening in the streets of Philadelphia or, frankly, streets everywhere in Pennsylvania. They're simply saying we've made a policy judgment that the answer to that is not what you want. And that's unconstitutional. Isn't that what we send them to the legislature to decide, those fundamental things of how do we best address the ills of society? They make those calls.
Your Honor, let's go back to the legal standard here. In order for a statute to surpass muster, constitutional muster, we are declaring it's a fundamental right. In that case, the statute must be necessary to promote a compelling government interest, and that the interest must be effectuated by the enactment of the statute.
Are you raising a facial challenge to the statutes or a facial challenge?
It's an as-applied challenge.
It's as applied. And what is the fact? So you think that the FPLs could be constitutional, but something is happening so the FPLs are not constitutional.
Let's talk about our petition for review. We propose 3 different regulations that Philadelphia.
And by the way,
act.
in your petition for review, you don't say the FPLs are unconstitutional. You say the respondents are acting unconstitutionally.
Yes. Well,
so it's 2 different things.
the respondents are acting constitutionally by enacting, maintaining, and expanding the FPL.
Well, they have to maintain them because the laws are presumed constitutional until a court says otherwise.
They don't have to maintain them if there's evidence of constitutional action. But let me just
Counsel,
respond. Yes, Your Honor.
may I sort of focus this as the way I'm looking at this, which is maybe a little bit different. Every statute is a policy statement by the legislature. Every statute, every crime that's defined, every statute reflects a social policy. That doesn't mean that it can't be challenged. The statute itself can't be challenged on constitutional grounds, as I see it. We have cases like that all the time. Okay. I think what I'm struggling with to some extent, and I think my colleagues are struggling with, is the rights that you are advancing on behalf of your clients under Article 1, Section 1. We have read Article 1, Section 1 to protect the right of individuals to seek occupational goals. It's not stated in Article 1, Section 1, but it's a strong tie between pursuing their own happiness and advancing their property rights. I mean, we do that frequently. What I don't see here is a development of this Article 1, Section 1 right that you're advancing. To the contrary, I see a lot in your petition and in the argument that's presented that looks to me like an equal protection challenge. I mean, you're fundamentally saying you can't treat people in Elk County the same way that you treat people in Philadelphia, given the density of populations, the differences in demographics and things of that nature. But you haven't advanced that. So, I mean, to me, I'm open-minded on this idea that there is an Article 1 right that may be identified, and not in a substantive due process context. I'm talking about a fundamental right to be able to walk out of your house without fear of, but what is that? What do you call that? See, and that's what I'm struggling with. And I don't think that it's a negative to challenge a statute, and I don't think that we as the court can stand back and say, you're challenging policy. Every statute is that. But I just have a problem pulling together the threads of this Article 1, Section 1 right that you're relying on and advancing here.
Your Honor, I'd like to respond in 2 parts by sharing a history of such ordinances in Philadelphia, and then actually speaking to the standard. I think it's very important for us to shortly discuss the standard that we're asking the court to apply. Again, starting in 1790, the mayor of Philadelphia enacted a statute saying, hey, it's a permit to purchase. If you want to discharge anything, you got to get permission from me first. As we've laid out in our petition for review, Philadelphia has countless firearm ordinances, and still does, except for these firearm preemption laws. They would be applied. I'd like to, and that goes to the Article 1, Section 1. Again, the right to enjoy and self.
Your examples are excellent. I mean, and your argument is strong, except it's not based in an Article 1, Section 1 definitional perspective. And when I asked you to define the Article 1, Section 1 right, you went right to the examples of facts that support your argument. But I'm still struggling with what the argument is.
The argument is the right
to
enjoy life.
Okay.
To be able to walk out your front door without fear of crossfire. It is the right to defend yourself in enacting legislation locally to combat.
What's the yardstick you want this court to apply in determining and directing the adjudication of such a right? Is there a quantum of a jurisdiction's population that must somehow be found by a fact finder to live in such fear in order for it to rise to an Article 1, Section 1 violation? Is it just sort of a seat-of-the-pants feeling by the judge on how dangerous a particular jurisdiction is? Because if we grant your relief, presumably we don't want to instruct the trial court to just wing it or do what he or she feels or engage in sloganeering or impose his or her political or policy judgments. Again, matters left for the legislature. What's the constitutional yardstick beyond slogans about kids should feel safe, things we all believe in, that would actually provide a constitutional rubric rather than a policy or slogan rubric? Remember, as Justice Holmes said, if Congress wants to take us straight to hell, it's my job to help them get us there. So, if they make policy judgments, we only second guess them if they specifically violate the Constitution. So what's that rubric you want us to instruct the trial court to use?
Your Honor, we submit it's a fundamental right. But even if it's not, we are willing to play at the intermediate level or even the heightened rational basis level. You referred to Laud, Justice. Even the heightened rational basis letter. Let's take the heightened rational basis that this Court has articulated time and time again. This is not an economic right, Your Honor. This is not a Lochner-era right. This is a right to leave your home, what I would say is a fundamental right. If we're playing at that level, the statute just is too broad. Under that standard, statute is deemed unconstitutional if it's unreasonable, unduly oppressive, or patently beyond the necessities of the case. Your Honor, our petition for review included 3 different regulations, not one of which implicates uniformity. A permit to purchase wouldn't implicate hunters coming through Philadelphia. It would implicate Philadelphia residents choosing to buy a firearm. There is simply no issue of uniformity, and yet the court below didn't even consider it. There was, yes, Your Honor.
I find your facts compelling. I find your arguments compelling, and I sympathize with the fundamental basis that you're providing for your argument. But I guess the 2 problems I have are, number one, the remedy. Even if we accept everything you're arguing as true, and when we read the papers, we even if we're not from Philadelphia, we know what's going on. We know what's going on in Pittsburgh. We know what's going on in other parts of the state. But isn't the remedy under our system of democracy here in Pennsylvania to vote those legislators out of office if you don't like what they're doing? It's the General Assembly's job. The individual members of the General Assembly are elected by the people, and if this is an issue that needs to, go on a completely different course, then to me, it seems the remedy is through voting and through election. Secondly, I think that Justice Dougherty made a tremendous point on enforcing the existing laws that we have for the protection of Philadelphians and other Pennsylvanians. And if the head law enforcement officer is not pursuing those kinds of prosecutions, isn't your ire or your argument best directed toward him? So I know that was two questions, but if you could address them both, I'd appreciate it.
Thank you, Your Honor. I'd like to begin with essentially a political question issue raised. This court wrestled with that same question in Robinson Township. The question is not, the question here is, does the legislation violate the Constitution? It's not a policy question. As this court said in Robinson Township, responsive litigation rhetoric, raising the specter of judicial interference with legislative policy, does not remove a legitimate legal claim from this court's consideration. The political question doctrine is a shield and not a sword to deflect judicial review. Your Honor, we're seeking judicial review here. With respect to Your Honor's question and the question of, what's actually happening on the ground, respectfully, those are fact questions. We're at the preliminary objection stage. You must accept our well-pleaded facts. And at the time in the Commonwealth Court, if the Aplts wish to provide facts, actual facts supporting their claims, they are able to do so. But we are not at that stage yet, and we submit the facts that we provided, which, by the way, come way before the current policies of the current DA. We have witnessed violence on the ground for decades, increasing, but we have witnessed that for a decade.
Which brings me to this question. Share with us how you distinguish the facts that you're presenting today, similar to or distinguish them from the facts of Ortiz versus Commonwealth, the similar facts in 1996, in which this court ruled against your position. How are you distinguishing these facts from Ortiz?
Thank you, Your Honor. Ortiz was a completely different set of facts and a completely different set of legal arguments. In Ortiz, the city of Philadelphia and the city of Pittsburgh brought an action asking for declaratory injunctive relief with respect to assault weapons ban. And they did so primarily under one argument. They said, hey, we're home rule municipalities. You can't tell us what to do. And by the way, this is not uniform. There's a separate section applying to Philadelphia. This is not uniform. And the court said, are you kidding me? It is uniform. It specifically says it applies to everyone. No, Philadelphia, you're not special. But moreover, this court did not investigate and did not interpret Section 6120 because the statute at issue, in the court's own words, was undisputed to purport to regulate ownership, transfer, possession, and transportation. That is simply has been interpreted for decades now as field preemption. This court never said it. In fact, within the sentence of a statewide concern, and I will read it to you, it says, the court said that because of the ownership, which again is one of the 4 categories of conduct preempted under the statute, because of ownership of firearms is a constitutionally protected, its regulation is a matter of statewide concern. Ownership, of course, is one of the exempted categories of conduct in 6120. But even when a matter is of statewide concern, as this court held in Robinson Township, that is not sufficient to immunize it from judicial review.
Let me just say, counsel, I don't think there's any jurist on this or any other court who would deny all these years after Marbury that courts have the power of judicial review. We don't need to, that's been settled for 220 years. But again, you have to give us a hook. So in the ERA cases, we have the ERA, right? In the education case, we have the education clause. Here you have the inchoate right to life, liberty, and defending life and property, et cetera, under Article 1, Section 1. And we could go around this room if this was just a conversation, and we get 60 different views of what those mean. So beyond taking a poll here and saying, what do we think is reasonable, why are we here to do what you haven't been able to get the General Assembly to do? I assume you try to shame them, try to show them the evidence, try to explain to them about gun violence or why Philadelphia is different, et cetera. what's the hook? What's the test other than just sort of, we feel it's unreasonably inflicting dangers to life more in Philadelphia, so strike this FPL down?
Your Honor, we brought two claims. One is a straightforward Article 1, Section 1 violation, a violation of right to enjoy life and liberty. The second is a state-created danger claim. And in that, we have identified a discrete class of individuals who are suffering at the affirmative actions and the deliberate indifference of Aplts here. You're right. Aplts have been told time and time again about the harm, the debts, the fear that exists in these neighborhoods. And they've set that aside. Your Honor, that is deliberate indifference.
You're going to attempt to prove on the state-created danger trial. You're going to present these proposed ordinances that you may or may not be able to pass. They're just sort of proposals at this point in time. And you're going to put forward evidence that says, oh my gosh, if we're allowed to enact these, all of a sudden everybody's life and liberty is going to be protected. So you need to allow us to do this. How is a judge going to reach that determination? How is a judge going to decide, and what is the, as Justice Weck would say, the yardstick or the metric that the judge is going to say, oh yes, I am convinced that if these laws are passed, life and liberty will now be protected, and therefore I'm going to issue an order that says, state legislature, who are the respondents, you somehow can't stop them from doing this. What's that test going to look like?
I'd like to take your question in parts, if that's okay. You suggested that they were proposals. In fact, all three laws are currently codified but have not been enforced but for the firearm preemption ordinances. So they would go in effect if the statutes are deemed unconstitutional. In terms of evidence, that is what a trial court does on a daily basis.
What's the test? I mean, that's what I'm saying. You're going to put forward evidence that is going to try to convince the judge that, Judge, that right now, Judge, life and liberty is being deprived because the General Assembly isn't giving Philadelphia, I mean, we keep picking on Philadelphia, but Pittsburgh's in here too, because the special laws you have given to Philadelphia, and there are some special rules that have been passed just for Philadelphia by the General Assembly, don't go far enough. And therefore, because they don't go far enough, you, legislature, are depriving them of life and liberty. But we have this group of laws that if you allow them to go into effect, all of a sudden the scale tips back and life and liberty will be protected. What is the test that a judge is going to apply other than saying, yeah, I think those new laws would be great, and that's going to change the constitutional weight?
Your Honor, we put forward a petition for review, and we have here empirical evidence backing up these three laws. Let's talk for a minute about the permit for purchase. You heard me mention Judge, Justice.
I know you're going to put evidence on. They're going to put evidence on too. I'm just trying to figure, is it, this is the Constitution, the statutes are presumed to be constitutional, absence clear, it's a very high standard. Is that the standard you're saying, that your evidence has to show that has to rise to the level of a clearly palpably unconstitutional, or do you just have to get a judge to say, yeah, I like their evidence more than your evidence, and therefore they win?
Both Claims 1 and Claims 2 have known standards, a substantial factor. If the actions, if the prohibition of municipalities like Philadelphia from enacting firearm legislation is a substantial factor in the constitutional violations, you have Claim 1. Under Claim 2, a part of the standard of a state-created danger is that it must be fairly direct and foreseeable. Your Honor, the violence we're witnessing here in Philadelphia and Pittsburgh in these segregated neighborhoods wasn't just foreseen. It was foretold time and time again on the General Assembly's floor and ignored.
Where does the standard of clearly, plainly, palpably violate the Constitution come into play in this dynamic?
Your Honor, it is certainly there. It is certainly there, but we believe we meet it, and we should be given the opportunity. Again, I remind this Court, we're at the preliminary objection stage. At this stage, a demurrer should only be sustained in cases that clearly and without a doubt fail to state a claim. In the court below, first of all, we only have one judge who actually signed the plurality. The others signed the judgment. One signed a concurring. So we have one judge who signed the plurality opinion. She did not actually apply the standard. Under our Article 2 claim, you have to actually apply the standard. look at a means-end analysis, conduct the means-end analysis, weigh the interest. There was none of that.
Can I follow up on that?
Yes, Your Honor.
Means analysis. I think Justice Brobson asked you an astute question about the world before and the world after. Because if we grant your relief and you go back to the trial court, so we're talking about one judge, chancellor, right? So that would we expect that the fact finding would include a required assessment by that jurist of scenarios in which in this case, the Council of the City of Philadelphia has passed various legislations, and the outcomes have been exemplary, such that you have a perfect fit between the remedy granted and the outcome. So you have the before world characterized as bad, and the after world, after they've been free to legislate, excellent, so that we could say with some level of confidence that the relief you're seeking would actually lead to a remedy for the constitutional violation you allege. Do you follow what I'm saying?
I do, Your Honor.
Would that be the kind of perfect fit analysis we'd expect the trial court to conduct if you can go forward?
The trial court would weigh the evidence. Let me just speak for a moment about the permit to purchase laws. When Connecticut instituted a permit to purchase law, they witnessed a 40% decrease in firearm violence. When Missouri rescinded their permit to purchase law, in the course of 3 years, a 27% increase in firearm violence. Since then, a 47% increase in firearm violence. And let me be very clear, at the time, all other violence remained steady.
How many of those jurisdictions have an Article 1, Section 21 right?
Your Honor, I'm happy to propose a letter on that. I do not know, but I do know that the right to bear arms is a fundamental right, and we're not disputing that. And furthermore, no party has suggested that the proposed regulations that we have would implicate Article 1,
No, but again,
Section 21 rights.
I think I'm going to count on myself. I'm repeating myself. There's a lot of factors that the General Assembly takes into account on policy questions like this. And one of them I have to think that they're thinking about is their duty under the Constitution to protect that Article 1, Section 21 right, the balancing that has to be done to consider your claims and concerns about life and liberty. And you want to argue that it doesn't impact the right?
We submit it won't, Your Honor.
Well, you want to argue that, but the General Assembly may make a different call. And the hard time I'm having is I think similar to some, but not all of my colleagues. Is I'm just trying to figure out whether you lost you've lost your argument in 2 lanes of the highway, and the lanes are divided, and you're now jumping the berm into a 3rd lane, and we really don't have anything to do here.
Your Honor, as you did in Robinson Township, you can declare a law unconstitutional.
Well, Robinson, you keep bringing up Robinson. Robinson was completely, and Justice Wilk said it, but Robinson was completely different. Their states had been, the state had authorized through the Municipality Planning Code the authority of local governments to actually zone. They had done that. And then the General Assembly comes along and passes a statute that took that away in certain respects. That was the circumstance you have there. The FPLs have been in place for quite some time. And there's not an existing law. You're not here saying, we've had this law in Philadelphia for a long time, people have relied upon it, and now the General Assembly has now passed a new statute that is preempting that.
Your
That's
Honor,
not what your claim
absolutely
is.
Saying that is the permit to purchase statute that was part of the Schneck.
Well, how long ago did that happen?
That was in 1978, and
Right.
we've been trying to get before this court, sadly, for the past 50 years to clarify, and last 30 years, at least since Ortiz, to clarify what 6120 actually does and doesn't. If 6120 is not a field preemption statute, there are other cases pending before you. City of Philadelphia v. Armstrong, for instance, that is about a lost and stolen ordinance. If the City of Philadelphia can actually have a lost and stolen ordinance on the books, that would be tremendous. But right now, nothing.
Question, counsel, about, as you say, clarifying 6120. I mean, the wording of 6120 seems extremely clear. It may be stupid, it may be unreasonable, but they've clearly said that you can't regulate, that localities cannot regulate firearms, and they've got all sorts of belt and suspenders language in there. What you use the word clarify. It was the Ortiz, I thought, dealt with that, and it reminds me of that Lori Morgan song, "What part of no don't you understand?" I mean, it says no. It says no, and you want us to clarify that. So what is it that's unclear about 6120?
Your Honor, as this court held in Hoffman Mining, when the General Assembly clearly needs to evidence an intent to preempt a whole field, Your Honor, there are so many caveats in this statute that have never been given any sort of indication by this court. If you look again to the enactment of in 1974 of 6120, Ken Shalehammer at the floor of the General Assembly said, "I'm trying to help those sportsmen and huntsmen coming through Philadelphia. That's why we have carried and transported." Carried and transport has been given no meaning under Ortiz. This court never actually interpreted 6120 in Ortiz because it didn't need to. We all could agree that banning assault weapons would actually regulate ownership, and lawful ownership at that. Lawful has meaning too.
So you think Ortiz was correct?
Your Honor, I'm not going to dispute whether Ortiz is correct. I do represent the city of Philadelphia. However, I will submit Ortiz never regulated, never said it's a field preemption statute, because this court would never say that, because its jurisprudence shows that you actually have to read the words of the statute. The court, again, going back to judicial history here, or legislative history, the initial legislation actually used the words, "and we preempt the entire field." That is not what was enacted. This is very much a legislative compromise. But again, this court never had the opportunity to interpret 6120. So I think it is very important.
I'm sorry to interrupt you, but 2962, what about that one? A municipality shall not enact any ordinance or take any other action dealing with the regulation of the transfer, ownership, transportation of, or possession of firearms. Again, presumably you could have a plebiscite in this room, and maybe you get 99% saying, "Boy, is that stupid. We hate that law." But isn't that a very clear statement by the legislature of what they decided? How do we clarify that, to use your word?
I think it's important, Your Honor, that 2962G is not the same language as 6120. It does not have the carried and transported language. It is different. And we can't just assume the spirit of the law. We can't set aside plain text, as this court requires, with regard to what we think is the pretext of the spirit. We actually have to go to the plain text, and that's what this court does time and time again. It just hasn't done here in 6120. So at a minimum, we invite this court, as you've done in other cases, Robinson Township, Scampone, providing guidance to the lower court, saying, we never said in Ortiz that it was a field preemption statute. Moreover, Ortiz dealt with home rule issues, not Article 1, Section 1 issues.
Yeah.
The judicial responsibility must always cede to interpreting the constitutionality of a statute. Yes, Your Honor.
You don't get you won't have a rebuttal, but based upon your argument and your facts today, how would you counter the potential argument that since Philadelphia and Pittsburgh are war zones, that what you're requesting justifies an increase in the use of firearms in Pennsylvania pursuant to our statute, Article 1, Section 21, in defense of each other?
Your Honor, there's plenty of firearms in Philadelphia. I know other counsel have talked about, well, there's lawful firearms. Those are lawful. We're talking about unlawful firearms. Most of the firearms that attacked and killed the family members of petitioners were never found. We are talking about targeting unlawful firearms.
I don't understand that. How do you target an unlawful firearm? How does the statute target an unlawful firearm? Aren't there laws that already regulate the unlawful use of firearms, the unlawful possession of firearms? I think Philadelphia has its own ordinance dealing with unlawful possession of a firearm. I'm not sure they're enforcing it, but they have their own ordinance.
We're talking about trafficking. We're talking about when a gentleman, like Mr. Armstrong, again, that case is before you, goes and buys multiple firearms and then loses them. And then they show up at a murder scene. And then when they go to Mr. Armstrong the next day after recovering it, he's like, oh, I just lost it. When was the murder? The day before. That is what we're targeting, the illicit firearms on the street. And the other statute we're talking about, one purchase per 30
Is it
days.
illegal? Isn't it illegal to traffic in firearms?
And yet, the Commonwealth Court has said we can't regulate straw purchasers. Again, there is language in 6120 says that municipalities like Philadelphia cannot regulate the lawful ownership, transfer, transpossession of firearms.
Are you telling this court that the AG's office and the DAs in the counties aren't bringing VUFA cases? Because if that's the case, things have changed since I last looked at it.
Your Honor, they can't keep up. We can't keep up. There's firearms everywhere. And my point is, it's about prevention, Your Honor. This is not about punishment. I really would respectfully ask the court to focus on prevention here. We're trying to get the firearms off the streets before they even get there. So someone can't go and buy 10 assault rifles one day, go the next day, buy 50 more, and then lose them all. That is what we're targeting. We're targeting to ensure that someone who wants to purchase a firearm gets a permit, goes through a requisite background check, which is probably more exhaustive than what exists at the state level, to ensure that that person actually will use the firearm lawfully. That is what we're targeting.
I think those are superb points. I just am still not understanding how they belong in this forum rather than in a policy forum. I think those are astute and compelling arguments, and it is shocking, I suppose, that they don't get through a legislative mind. But I just keep perceiving this as you coming to us as a backstop for failing to get through to them. And I'm still searching for your constitutional litmus that we can instruct a trial court to apply to adjudicate this.
Your Honor, I'm going to come back to the two standards. Even if this isn't a fundamental right, which I believe it is, and multiple judges of the Commonwealth Court has agreed, let me just make that clear. Judge Ledbetter, Judge Seisler, Judge Wojcik, Judge Cohn-Jubilier have all said we're talking about fundamental rights here. So even if a fundamental right is not at stake, let's take the plurality's decision and say rational basis or a heightened rational basis is appropriate. Then the purpose of the statute must actually meet the interests. So if uniformity is indeed the purpose, it sweeps way too broadly, Your Honor. None of the proposed regulations, which again are already on the books, implicate uniformity. I'm asking for the court to apply the tried and true test of judicial constitutional scrutiny. Fundamental right, I would prefer it to be a compelling interest because I believe that is what's at stake. But even at other levels, we meet that. With state-created danger, there's 4 different actions that must be met. We've met that. It is an affirmative act. The state has acted with deliberate indifference. Plaintiffs are part of a discrete class of plaintiffs subject to harm.
I don't want to interrupt. The affirmative act, deliberate indifference being they are not repealing the firearm presumption laws?
It's everything, Your Honor. It's from the enactment, the maintenance, and the expansion.
Well, then the governor should be here too, because the governor signed.
And the governor of the Commonwealth has been sued, Your Honor.
But
Attorney Hoa, you have presented a tremendous argument. Unless there are any other questions, I'd like you to sum up.
I actually have
Sure.
just a focus for my perspective. In your state-created danger claim, your focus on the foreseeable victims appears to be, from what I'm understanding from your petition and your argument, is that we're talking about members of the minority community, racial minority community.
I want to be much more clear. It's not members of minority community. If you're living in Rittenhouse Square, you're not a part of that group. It is those individuals who live in the poorest segregated communities in Philadelphia and Pittsburgh. And, Your Honor, when we are at the trial stage, back before the Commonwealth Court, which we hope we will be, we can identify by census tracts what communities we're talking about. Sadly, it is that apparent. We know where the firearm violence occurs, and we can identify it.
And they aren't minority communities.
They are. They're black and Hispanic predominantly.
You really don't have an equal protection claim then?
Your Honor, I think it's narrower. I think it's narrow.
What is narrow? You think
what we're trying to do here, again, we brought 2 different claims. One is a straight Article 1, Section 1 violation, and the second is a state-created danger claim. As a part of our state-created danger claim, our discrete class are those communities, poor, segregated, in Philadelphia and Pittsburgh that are subject. It's not the entire community, Your Honor.
Well, you can't say that with total confidence. I mean, there may be leanings that way, but there are a lot of shootings right now in the business district of downtown Pittsburgh, and I believe also in downtown Philadelphia. So it's not exclusively as you're alleging.
But that doesn't make it
That
better,
goes to a
does it?
factual argument, Your Honor, that we hope to present before the Commonwealth Court. Again, many of the issues you raise are indeed factual issues that we hope to have the opportunity to present before the trial court, the
understand.
Commonwealth Court.
Can I ask one more question?
I want to follow up.
Well, let me just ask a question about the interplay of the various statutes that are on the book that appear to be aimed at precluding any local control over firearms. I mean, is that true? Because, I mean, if Ortiz says what my colleagues think it says, if the statute that prohibits local municipalities from regulating in any way firearms, I mean, where are we going with this? I mean, is there, by virtue of the panoply of statutes out there, evidence of field preemption by the legislature?
No, Your Honor. In fact, in 2021, the House passed a bill trying to declare field preemption. Now, why would the House bother passing a bill to declare field preemption if there's already field preemption?
Because you want the answer to that? Because they don't know what the courts are going to do if a challenge comes up. They had Ortiz, they're uncomfortable with it, and they want to do a belts and suspenders approach. Happens all the time.
They're uncomfortable with it, respectfully, Your Honor, because this Court has never said that. The Court has never said that there's field preemption because the plain language of the statute does not provide it. It regulates 4 categories of conduct: ownership, possession, transfer, and transportation.
So why not?
That conduct has to be lawful.
Why not have a true Ortiz case? Why, instead of bringing this, why didn't you just start enforcing your ordinances and have it come up and have an Ortiz challenge?
Because people are dying because their fundamental rights are being violated on a daily basis, Your
So
Honor.
start enforcing your laws that you think would do that, would
Your
protect
Honor,
those
we
rights.
haven't. You respectfully, there are 3 other cases pending before you. I respectfully request that you take those 3 up as well. You have an opportunity here to provide guidance to the lower court, clarifying, if I may use that word, what Ortiz actually meant. You've done that in many other cases, forum nonconvenience, for instance, and say what you meant in Ortiz. You never said the word field preemption because field preemption does not exist. And then, when we're back before the Commonwealth Court, they will not use field preemption as some sort of shield to not actually look at our claims, and you can take up these other cases that are waiting to be before.
All right, any other questions from my colleagues? All right. Do you want to sum up, counsel?
Your Honor, firearm violence, for my 3rd claim, is a public menace. Our hospitals in Philadelphia are overwhelmed. As you read from the amicus brief of trauma surgeons, people are dying on a daily basis, and that is all we're seeing. And it's scary. It's frightening. We respectfully request that the Court reverse and remand the decision of the Commonwealth Court and give us an opportunity, our day in court, to vindicate the rights of our appellants. Thank you.
Thank you, counsel. Mr. Collins?
Police Court, Tom Collins, Buchanan, Ingersoll, and Rooney. I'm here on behalf of the General Assembly. And I'd clarify that I'm here on behalf of the General Assembly, both houses, both the Senate and the House of Representatives. I'm here with my colleagues, Anthony Holtzman, who's going to be representing the interests of Senator Ward, who's the President pro temp of the Senate. And I'm also here with my colleague, Dan Mullen, who's a Deputy Attorney General, and he's representing the Commonwealth in its capacity.
Counsel, just for clarification, how does Senator Ward's interests differ from that of the entirety of the General Assembly?
I would hate to start an argument with deferring to a colleague, but I do not represent Senator Ward. I would say that as the Speaker or as the President pro temp of the Senate, that her interests are aligned with those of the General Assembly.
Well, and she's listed separately as a party who was sued.
Yeah, that's correct, Chief Justice. She's also a named party, but I don't view her interests or her arguments to be out of step with the presentation of the General Assembly today. I think we're all walking hand in hand relative to the arguments that are about to be made. Did that answer your question?
Although her brief went a little further than yours in certain respects.
We're all here today in different capacities, and in some of the briefing, we'll take a little different tact or go a little further, I'm sure. From my perspective, however, I'm here to speak on behalf of the General Assembly, both houses.
All right, please proceed.
Okay. Now, we've also gotten together and agreed to kind of bifurcate our argument somewhat. I'm going to try to, as best I can, stay focused on the constitutional authority of the General Assembly to legislate in the area of firearms and what exactly has been done. I'm also going to address in a limited fashion the principles of Ortiz that apply upon those rights of the General Assembly, and then I'm going to address specifically the third claim that's been raised in the petition, which is essentially the delegation claim.
And I would caution co-counsel that while you represent separate parties, we don't want to hear a regurgitation of the same arguments. If you have something new to add, we're happy to hear from you, but not piling on to his arguments.
And I'd acknowledge that and ask for some indulgence because I'm sure I'm about to step on some toes relative to the issues.
But it's preliminary, and you are precipitorily stepping on their toes, so it's they who will suffer, not you.
Step away.
That's absolutely correct. I'll get going then. I don't want to spend too much time on the background of the case because the court's obviously well familiar with the facts, the specific allegations that have been raised in the case, and the various constitutional and statutory implications that are here. What I would like to talk about at the outset, though, is from the perspective of the General Assembly, this is a Article 1, Section 21 case in search of a constitutional right, and that the right that is being sought to be protected actually infringes and impinges upon the constitutional authority and the constitutional rights of the General Assembly. And specifically, I think we need to be careful about, unpacking the argument in the sense of the city of Philadelphia has no Article 1, Section 21 rights. Those are individual rights guaranteed by our Constitution.
It's Article 1, Section 1 rights. Isn't that
I'm jumping ahead. Yes, you're right. I apologize, Your Honor. Article 1, Section 1 rights. The city of Philadelphia has no Article 1, Section 1 rights under our Constitution, okay? Likewise, the individual defendants, while they certainly have Article 1, Section 1 rights under our Constitution, they have no right to legislate. And the petitioners pull those two things together in seeking relief here, that it is essentially, from my perspective reading it, because I'm not entirely clear the right that's being asserted either, but it seems to be a right of the individuals to seek redress and regulation through the municipality to protect them from third-party harm. And I'd ask the court as I go through my argument to also keep in context the fact that individuals, it's been found, don't have an individual Article 1, Section 1 right to protection from the state, from the acts of third parties. That in order to proceed with their claims facially, they must establish that the state has done something directly to harm them. And with that construct and backdrop, I'll move through what I think are the pertinent or germane constitutional provisions.
Counsel?
Yes.
It's Justice Donahue. Do you see that, or do you agree that the individual plaintiffs have an Article 1, Section 1 right to be free from fear of being gunned down on the street? And I'm making that up as a right. But, I mean, the right to freedom and liberty of movement on the streets of Philadelphia. Is there a right? Is there a right here? I mean, I'm having a hard time articulating it, but I mean, don't people have a right to be comfortable in their movement?
You're having a hard time articulating it because likewise, I'm having a hard time understanding it. And I think the direct answer to your question is no. And again, I'm stepping on toes over here with respect to responding to this, but no, because that would embody a right to be protected by the state from the violent acts of third parties. And that is not an individual Article 1, Section 1 right that a citizen of the Commonwealth has.
But the act here, they're really complaining of as a constitutional violation necessarily must be the act of the Commonwealth in maintaining this allegedly unconstitutional law, not the violent acts of third parties.
I think that's a distinction without a difference in the sense of the statute that they want would theoretically stop the act of the third party, but that is then, a right to protection from acts of third parties. And that's a very slippery slope. I mean, I believe, Justice Weck, you've raised the issue of where, if we start down this road, where do we stop? The Commonwealth regulates speed limits on the turnpike. What if specific, counties or municipalities along the turnpike decide that car accidents are also a very dangerous, thing to the public health, and decide that they want the speed limit to be 55 going through Cumberland County, where I live outside of Harrisburg? It's at what level does that stop?
But the state allows local municipalities to determine what the speed limits are on various of their streets, given the conditions of the locality and the need to protect citizens. So that doesn't. Local municipalities do that. Some places it's 35 miles an hour, sometimes it's 50 miles an hour, all left up to the local municipalities based upon local conditions.
Because the General Assembly has authorized that. And here we have, we've got in Article 2, Section 1, the legislative power of this Commonwealth shall be vested in a General Assembly, which shall consist of a Senate and a House of Representatives.
So without constraints, the General Assembly can decide if and when it wants to give local municipalities the ability to apply local knowledge to the needs and concerns of their citizens.
Absolutely.
Okay.
That's an Article 9 issue under our Constitution, is that pursuant to, and that's my fundamental argument here, is that Ortiz was in fact decided correctly, that Ortiz is not necessarily a doctrine per se, it's just an acknowledgement of our constitutional structure. And that constitutional structure is that under Article 2, Section 1, we have a tripartite form of government, that legislative actions are to be undertaken by the legislature. That under Article 9, we have a structure where cities such as Philadelphia and other municipalities can have home rule, but their home rule is subject expressly to powers granted by the legislature, and to the extent that the General Assembly has not withheld a power, because that's expressed as well in Article 9 of our Constitution, that the right that they ask to be recognized, which again, I can best articulate it as the right to lobby or to seek from their local municipalities regulations prohibiting violence, or at least attempting to limit or reduce violence resulting from firearms from their local government, when they still have those rights relative to the General Assembly. As many of the justices have pointed out today, there's nothing that would stop these same petitioners from making all of these arguments, some of which compelling to the legislature. They've not found redress there, and they are now back here asking you to create a right in Philadelphia, because that's fundamentally what they're doing.
But to be fair, Mr. Collins, they have found some redress, because the General Assembly has enacted some laws, particular to Philadelphia, in fact, to allow them to impose some regulation.
Yes, Justice Robinson, that's absolutely true. In fact, if you read the appellant's papers and the petition below, you would almost be left with the idea that the General Assembly passed the firearm preemption laws and then stopped there. And when the reality is that the Uniform Firearm Protection Act is broad-based and covers ownership, background checks, possession, all of the things that they're seeking to do, they're embodied already in the Uniform Firearms Act. And to Justice Dougherty's point, in Section 6108, I believe, of the Uniform Firearm Protection Act, there has been, and back to Justice Brobson's point, a specific carve-out for Philadelphia, which would require a permit to carry within the city of Philadelphia. So, again, the arguments that if we had a permit to purchase, that would somehow now trump the fact that there's already a permit to carry requirement in Philadelphia, as acknowledged by the General Assembly through its enactment and adoption of the Uniform Firearms Act. So, and that goes to, the arguments that were made previously by appellant very artfully, that the Uniform Firearms Act, the firearm preemption laws wouldn't touch any of these three things. Well, if we already have a background check under the Uniform Firearms Act, what is the permit requirement to purchase going to encompass? Yes.
That's a good question, and I'd like you to share with us. Section 6120 bars Philadelphia from passing any laws regarding the lawful ownership, possession, transfer, transportation, firearms, ammunition, or ammunition components. However, where in that statute does it prohibit the city of Philadelphia from enacting a permit to purchase ordinance, considering part of their argument is the use of gun trafficking, particularly in Philadelphia, not ownership, trafficking. So how does 6120 prohibit Philadelphia from passing a permit to purchase?
I'm going to look at the statute itself, and I think we have to look at it in its entirety in that context. And the statute itself, the Uniform Firearms Act at Section 6120A, provides expressly, no county, municipality, or township may, and I'll put emphasis on the following three words, in any manner regulate the lawful ownership. So the permit to purchase requirement would go directly to, that would be Philadelphia interfering with a citizen's lawful ownership, because
they're not owning it. They're purchasing it as a conduit to sell it on the streets of Philadelphia to kill our kids. Are you now saying what the mens rea of the individual purchaser is? I'm buying guns, like 50 guns, so that I could distribute them through the streets of South Philadelphia for $15. I don't want to own one of them. Why can't Philadelphia prevent that local crisis by having a permit to purchase?
Those are, I'll first acknowledge that, and I should have said this when I started this, I planned to, but I didn't, that none of my arguments here today are intended to detract in any way from the harm and the pain.
We got that, but I'm strictly looking at the statute and the language of the statute. I like the concept of municipalities can't, but it gives you 4 clear, unambiguous actions: ownership, possession, transfer, transportation of guns or bullets.
I'll address it head on. Like the two provisions I think you're talking about with respect to your example are the permit to purchase. That directly impacts ownership, my ability to purchase a firearm. I can't own a firearm until I purchase a firearm, I guess, unless I steal it. And then with respect to the one gun every 30 days, that is an express limitation. Both of those are express limitations that Philadelphia would be putting on the acquisition of a firearm that are directly contrary to 6122, which says no county, municipality, or township may in any manner regulate the lawful ownership. And relative to lawful ownership, there is no requirement under state law to have a permit to purchase, nor is there any requirement limiting a purchase to one every 30 days.
But reading the materia with 6108, in which the General Assembly specifically permitted the city and county of Philadelphia to regulate the licensing to carry a firearm on the streets of Philadelphia, that goes hand in glove then. So are you not taking into consideration that the General Assembly has 6108, which in fact carrying firearms on public streets or public property in Philadelphia, and the language is very clear: no person shall carry a firearm in this city of first class unless such persons is licensed to carry a firearm. And then if the city were to have a permit to purchase, arguably that falls in with the ability to license.
Well, the logic there is that who's making the rule? in the sense of, with respect to the requirement or the prohibition in 6108, it's derivative from the Uniform Firearms Act, which was promulgated and enacted by the legislature, which under our Constitution had the authority to do so. And our legislature also has the constitutional authority to limit Philadelphia's ability to do so. And through its adoption and enactment of the Uniform Firearms Act, it's chosen to allow, well, first of all, it's put forth a comprehensive structure regulating the acquisition, ownership, possession, transportation of firearms, but it's also carved something out for Philadelphia specifically as a city of the first class. It was the legislature's decision to do that. That was a policy decision made by our legislature that the circumstances in Philadelphia warranted different treatment and a deviation from the otherwise uniformity of the Uniform Firearms Act. As to something else I wanted to talk about relative to uniformity, there are the appellant's papers seem to frame the issue entirely along the lines of an individual traveling through Philadelphia needs to know what the rules are in Philadelphia and that that's the uniformity that the General Assembly is looking for. There's another key component here, and that is that, you know, the rights of one citizen, there was a reference to Elk County. I grew up in Elk County. I was born and raised.
Beautiful county.
What's that?
Beautiful county.
Beautiful county with lots of elk. But, you know, that the rights of a citizen in Philadelphia should be no different than the rights of a citizen in Elk County, and that a citizen in Philadelphia should be no more burdened with a constitutional obligation to get a permit.
Do
And
people hunt in Philadelphia?
people do not hunt in Philadelphia, but they have the same need. And the other thing the legislature is trying to do, as I think Justice Brobson commented on a number of occasions, is balance a fundamental constitutional right relative to Article 121 of our Constitution. That is the right to bear arms. So I don't believe that citizens hunt in Philadelphia, but that unfortunately very well may be true. But those citizens in Philadelphia have that same fundamental right to bear arms for their own protection in Philadelphia that they do in Elk County. In Elk County, they also tend to hunt.
A lot.
What if you have two competing fundamental rights?
I will start my response to that. I've not heard articulated any right by the petitioners whatsoever, let alone a fundamental right, because, again, they have no right to protection from violence of third parties. They have no right to legislate, no power to legislate on an individual or collective basis.
Let's assume it's a fundamental right to enjoy life and liberty, and then you have a conflicting fundamental right to bear arms.
I think you have two conflicting rights. I think you have a conflicting right on behalf of individuals to bear arms for their own protection, which would then, if the court recognized the fundamental right under Article 1, Section 1, would have two conflicting rights there. But it would also cause this court to deviate from our constitutional structure of government, which is what I'm here defending today. And that is that under Article 9, our Constitution grants to the legislature the sole right to legislate in the areas of public health and safety, including firearm regulation.
But it doesn't give the legislature the right to determine the supremacy of one right over another. That's this court's job.
That's exactly right. And I would say that if this court could find a fundamental right, or frankly any right relative to petitioners, then certainly, as this court did in Robinson Township, that this court would be empowered to, that's a fundamental separation of powers, right? The legislature has the ultimate authority to render legislation. This court has the ultimate responsibility for deciding whether or not that legislation violates our Constitution or an individual right. But it fundamentally, Justice Donahue, requires this court to find some right which does not exist in the individual petitioners, and the city of Philadelphia has no such right. Back to where I started, that there are buckets here. And the city of Philadelphia, with respect to ceasefire PA, they have no rights, at all. With respect to the city of Philadelphia, you have the right to legislate, theoretically under its home rule charter. And with respect to the individual petitioners, you have their Article 1, Section 1 rights, if they exist. But they don't have, even if they have a right to life and liberty, what is that right then? Is that a right to compel a deviation from Article 9 to have their municipality regulate firearms, or is it a right to petition their elected representatives, or as I believe Justice Todd referenced earlier, to lobby elect different legislators if they can't get the result that they want? This is a forum argument. It's not that these are bad ideas or bad arguments. It's that they should be made down the street, or I guess up the street from my office at 2nd and Straight at the legislature, not here.
Unless they have a fundamental right under Article 1, Section 1.
Unless they have a fundamental right under Article 1, Section 1.
And just so I understand, with respect to the public health argument that allowing this to happen in Philadelphia impacts the public health of its citizenry, is that just preempted in your view?
Well, I would observe that it didn't get a lot of time during the principal argument. I spent last night looking through both of those acts, again, page by page. I did not find any reference to firearms, guns, etc. I found there certainly is a reference to a menace to public health in the context of addressing disease, and certainly a specific delegation relative to addressing communicable and non-communicable diseases. However, we have to look, this court has to look at the plain meaning of that statute when reading it, and would have to come to the conclusion that disease equates to gun violence, which is an act of a third party, and to try to shoehorn, maybe look at it in the context of a square peg and a round hole. But
public health and safety is not the terminology used. Unfortunately, it's public health.
It's public health, and doesn't say public safety. But more importantly, those acts are enacted, I believe, in 1951 and 1955, and the firearm preemption laws come along in 1974. Even if you were to accept their arguments that the legislature either sloppily, utilized language that might encompass, crime and gun violence and crime later on down the road, they still run into a complete brick wall in the sense of what the legislature giveth, it can take away. And you have a very clear expression in 6120, A, that you can't do that. So, and that also distinguishes the cases that they've relied upon, the prison case and the Human Relations Commission case, wherein there you had expressions of obligation by the legislature without any curtailment. Here you have express curtailment. There should be no doubt after 1974 that those two health acts were not intended in any manner to encompass gun violence, and that Philadelphia should not be doing anything relative to gun violence. But I would take a step back. I don't think you even get there.
As a preemption.
Well, that's preemption. I think preemption, there's two, I think, equally applicable defenses. I mean, one, it's simply a plain meaning. This court has to look at a statute first and foremost from its plain meaning, because it is a statute, to determine whether or not there was delegation relative to the right to regulate firearms. That does not exist in the statutory language. If you, again, I did it again last night. It's a page turner. A lot of discussion of specific communicable diseases, a lot of discussion of what public health departments can do relative to communicable diseases and non-communicable diseases. There's no mention of firearm, regulation or anything like that.
All right, I understand.
Yeah. And again, if you do get there, it's preempted by the preemption laws. That's from our perspective, that's crystal clear. And on that note, unless the court had further questions of me, I think I've probably sufficiently stepped on everybody's toes here with respect to the other two arguments. I would like to say a couple, after offering to sum up and then pulling it back, I would like to say a couple things about the state-created danger doctrine. I would observe there from the General Assembly's perspective that the preemption laws were enacted in 1974. The harm that is alleged occurs decades later. That is, from our perspective, a bridge too far on the issue of foreseeability. We also cannot locate, and I don't believe Judge McCullough below or the Commonwealth Court were able to locate, and the appellants certainly cite to no case anywhere where the state-created danger doctrine was utilized to invalidate a statute. Further, the state-created danger doctrine requires an affirmative act. Not amending or repealing the firearm preemption laws, from our perspective, is not an affirmative act. And it would also require this equal body under our constitutional system of government to conclude that a co-equal branch of government had engaged in the kind of reckless indifference towards public safety that you see in the classic, state-created danger doctrine. And that's, I think, all I had, unless somebody has a question.
Thank you. Thank you. Let's move on then to Attorney Holtzman.
Thank you very much, Chief Justice Todd, Justices of the Supreme Court. My name is Anthony Holtzman with the law firm of K&L Gates. I'm here today with my colleague Tom DeCesar. We represent Senator Kim Ward, the President pro tempore of the Pennsylvania Senate. And I want to kind of pick up with something that Mr. Collins left off with and Justice Doherty touched on as well, which is the question of whether there is any affirmative act in this case such that there could ever be liability here on the part of the respondents in the case. So what we have here is a scenario where in the petition for review, the appellants fail to plead how, in particular, the preemption provisions that we're here to discuss today caused any of the individual petitioners or their family members to sustain a particular harm, or cause some third party to go out and cause harm to them or their individual family members, as opposed to something else causing that harm. And in truth, they can't credibly make those types of allegations because the statute did not actually cause harm in this instance, and it didn't cause a third party to cause harm, if you will. The harm was caused by independent acts of third-party actors, namely criminals, who were armed with firearms. And so instead, what the petitioners have said is that they or their family members have experienced firearms violence, and we join the chorus of people who agree that that is absolutely horrific, and they plead that in their petition for review on the one hand. But then they say that Philadelphia would be safer, in their view, if it were able to enact local gun control measures on the other hand. But what they don't attempt to do is meet their burden to plead how it's the case that the preemption provisions actually caused the firearms violence that's the predicate for their whole case, that's the predicate for their standing. And yet they point to that firearms violence as the reason why they have standing to challenge the preemption provisions. So that is a fundamental pleading defect that permeates both the substantive due process claim and the state-created danger claim. So, for example, if we're looking at the state-created danger claim, you don't even get to the four-part state-created danger test in any context, whether it's a challenge to a statute, a challenge to an action that an executive officer took, or any other action, if the state itself did not create the danger. Why is that the case? Because it's well settled under the law of substantive due process, and really the seminal case in this realm is the DeShaney case that the U.S. Supreme Court handed down in 1989, that, as Mr. Collins said, people don't have a right to have the government protect them from private acts of violence. So it is only the case that if the state interjects itself into the private realm and does something, an affirmative act in the private sector, that makes it more likely that a private actor is going to commit a violent or harmful act to another private actor, that the state can fairly be said to have actually taken an action at all.
But that's exactly what your opposing counsel is suggesting, that by failing to act, the legislature has created that danger.
Right, Your Honor, and I think that is sort of, if I could say it this way, sort of an attempt to engage in artful pleading, because failing to step in and protect someone from violence can't be an affirmative act, or else DeShaney doesn't make any sense. What was happening in DeShaney was, unfortunately, a father was beating his child in their home, and local government officials, social workers, and other local officials were being told, that father is beating the child in the home. You need to do something. You need to step in. You need to protect the child. They were told many times over, according to the facts of the DeShaney case, and yet they didn't intercede. They didn't intervene. Ultimately, unfortunately, the father ended up injuring the child to such an extent that the child had lifetime permanent damage. The mother brought a lawsuit against the local officials and said, you knew that bad things were happening. You should have known. We told you. And you didn't interject yourself into the situation and didn't
That's a
protect.
very specific factual circumstance, but in a broader sense, that is what your opposing counsel is arguing, that the General Assembly knows that people are being shot every day in Philadelphia, kids are being shot, and the General Assembly is not only not acting, but not allowing Philadelphia to act.
And, Your Honor, as Justice Brobson and others have alluded to, the General Assembly has heard many such arguments. They've tried to weigh, we've been down this road, they've tried to weigh the arguments. They've tried to certainly respect the right to keep and bear arms and try to weigh that out and come up with a balance in the Uniform Firearms Act that balances those things out. But if we just kind of look at it through the lens that the petitioners have set up here, and we ask ourselves, okay, so the General Assembly is telling the city of Philadelphia that through local enactments, it can't protect people. That's how they frame this issue. General Assembly says to Philadelphia, you can't enact local measures to protect private citizens from privately inflicted violence. Well, the city of Philadelphia is the government just as much as the General Assembly. It's a creature of statute, was created by the General Assembly to carry out governmental functions. So again, because there is no constitutional substantive due process right to have Philadelphia protect you from private acts of violence, to have the General Assembly protect you from private acts of violence, you're left with no case here.
So is the remedy in your mind, everyone has a gun or the residents move out of Philadelphia?
I agree with the sentiment that's expressed in different ways today, that the remedy is with the legislative process, it's at the ballot box, and DeShaney actually says that. The Supreme Court said on that issue, when it comes to substantive due process, if the state is the actor that can be fairly said to deprive someone of life, liberty, or property, then there could be liability for the state. If not, if the state has simply refused to step in and help, the remedy is in the political process, and the legislature can enact laws, of course, that protect people. They do that all the time. That's something to be sorted out through the democratic process.
The remedy in our democracy is to vote them out if you don't like what they're doing.
It is, and to petition the government for a redress of your grievances, which is a fundamental right that people hold as well, and they're perfectly entitled to exercise it in this instance.
May I ask, in Senator Ward's brief, you raise a waiver argument with respect to Ortiz. I don't want to spend a lot of time on it, but could you just briefly sum that up for us?
Yes, certainly, Chief Justice. In the proceeding below, the appellants did not plead or even argue at any point that Section 6120 is a field preemption statute as it's being characterized now. I think field preemption may be a bit of a misnomer. It's an express preemption statute that says the field is preempted. But in any event, they didn't assert that argument at any place in the proceeding below. And in fact, at one point in distinguishing this case from prior cases like Clark, which was a case I think from 2007 or 2008, if I've got that correctly, the appellants went out of their way to say that unlike what was argued in Clark, this case is not about interpreting the words of Section 6120. Indeed, as someone suggested earlier, may have been you, Chief Justice, if in fact the petitioners here believe that the preemptive scope of Section 6120 doesn't cover the ordinances that they're concerned with, there'd be presumably no basis to challenge 6120 on constitutional grounds. So the petition for review is clearly set up as a constitutional challenge, and there's no argument there or any briefing below about the preemptive scope of the statute.
So, Mr. Holtzman, how did Ortiz get into this case? Because there is no, or as I read the petition, there was no Ortiz challenge. Nobody was asking Ortiz to be ruled unconstitutional or clarified. This is not a challenge to a local ordinance that someone is arguing is preempted. It's a challenge to the preemption law itself. How did Ortiz get in this case?
Well, there is an argument, pardon me, that Ortiz should be overruled made by the appellants, isn't there?
Certainly not pled in the petition for review, and the argument that we've always understood this case to be centered on from the very beginning is a constitutional challenge to the preemption provisions and not any sort of Ortiz scope argument.
Okay.
You don't maintain, though, pardon me, You don't maintain, counsel, that in the course of deciding this case, if we found Ortiz to conflict with our conclusions about Article 1, Section 1, or any other aspect, that we could overrule it. You don't maintain that, do you?
No, Your Honor. I mean, of course, if the reasoning this court espouses in this case somehow conflicts with Ortiz, then of course it's entitled to overrule.
And I think we've preempted Justice Brobson's question, so if you want
I was hoping to get a chance.
I hereby withdraw my inquiry.
I'd be happy to answer it, though.
Yeah, I know. Not now.
I don't remember what it was at this point.
Counsel,
I've been preempted.
counsel, the Commonwealth Court certainly thought Ortiz had something to do with this case. I mean, it's not as though the appellants have interjected Ortiz into this case. Well, the Commonwealth Court focused almost exclusively on Ortiz, believing that it precluded the Commonwealth Court from granting the relief that two of the three of them, for the five of them, would have granted in this case. So Ortiz is in this case.
Well, Justice Donahue, I think you've reenacted Justice Brobson's question, perhaps, and so I'll try to answer.
Well, I did ask how it got in the case, and that was really directed toward the Commonwealth Court's at least the plurality opinions, using Ortiz. I'm not saying Ortiz isn't potentially relevant to our analysis, but Ortiz arises when, at least as I understand it, Ortiz arises when a local municipality attempts to enact a gun ordinance and it's challenged there's a plaintiff that challenges it as preempted.
Correct.
This is sort of the flip side. They're not challenging a local ordinance, they're challenging the constitutionality of the preemption statute itself, which I don't see as an Ortiz issue. Maybe I'm probably wrong, but I'm not saying Ortiz isn't implicated. I'm just saying it's not really this case.
I agree wholeheartedly, Justice Brobson, and one of the ways that Ortiz bears upon the case is that in Ortiz, this court explained some of the rational bases for 6120 in passing in some respects and not in passing in other respects. But as we pointed out in our briefs, this court explained in Ortiz that the constitutional right to keep and bear arms exists throughout the Commonwealth. And so, as we've explained in our briefing here, there is a legitimate government interest that the General Assembly has in trying to ensure that people's constitutional rights, and by the way, this is what makes this different than a lot of other cases involving legislation. We're talking about legislation that actually restricts or regulates a constitutional right, that is to say the fundamental right to keep and bear arms. And so the General Assembly assuredly has a legitimate state interest in trying to ensure, as much as it deems reasonable, that people across the Commonwealth have either the same level of restrictions or not on that fundamental constitutional right, no matter where they go.
Could I just go back to Ortiz? I promise this is the last time. But I've clarified my own recollection of the appellant's position. It's not necessarily that Ortiz should be overruled. It's that the plurality's erroneous application and misreading of Ortiz warrants this court's attention, and that lower courts have misread it, and we should consider clarification.
Yes, Chief Justice, I think that's a fair, I'll let the petitioners speak for themselves on how they characterize Ortiz, but I think that's probably fair.
Since I was reading from their brief, I think I spoke for them.
Okay, very good. But again, Ortiz does have that role, we think, in helping to illuminate the value that the General Assembly sees in seeking to ensure that people's fundamental rights are treated the same throughout the Commonwealth. And so I just wanted to, my focus today was really going to be mostly on the state-created danger doctrine, and I probably stepped on a little bit of toes as well as Mr. Collins inadvertently did. But again, I want to just kind of highlight, as I did at the outset, that there is no affirmative state action here. The statute at issue didn't interject itself into the private sector. It's basically just saying to Philadelphia, you cannot use local ordinances to regulate firearms. And so you don't trigger the four-part test that comes into play in traditional state-created danger cases. But even if you did, we heard before that generally applicable statutes like the preemption provisions, let's say you have a generally applicable statute that somehow does interject itself into the private sector and make a risk of harm more likely than otherwise. We don't have that here, but if you did, those are still historically, a statute like that has never been deemed to be unconstitutional for creating a state-created danger, and that is because, as the Third Circuit has said, quote, there can be no specific knowledge by the defendant of the particular plaintiff's condition, and there is no relationship between the defendant and the plaintiff, closed quote. So really what the court is saying is that this theory only makes sense if the state created approximate and imminent risk that a private party would cause harm to a particular victim or a discrete group of victims that could be readily identified and foreseen in advance, as opposed to what we have in a case like this one.
One could imagine, counsel, one could imagine or hypothesize outlandish species of legislations that would create a state-created danger and that wouldn't require that the exposure be to the acts of a third party, right? I mean, again, they would be infirm on other constitutional grounds, perhaps, as well. But, for example, if the legislature passed some outlandish law providing for something to be done in the city of Philadelphia by way of public works or a land feature of Philadelphia, that it could create a state-created danger, allowing for some sort of constitutional tort claim, I suppose, right?
I thought a lot about that question, Justice Wecht, and well, I think, first of all, state-created danger is triggered only when the state sets up a scenario where a private actor commits the harm, and that the private actor's harm is actually, or action is essentially ascribed to the state, because the state has essentially created a fact pattern where that private actor is much more likely to do something dangerous and harm somebody. Maybe there could be a statute, and again, this is just hypothesizing between us in this colloquy, but if the General Assembly enacted a statute that said something like all, and again, this would probably be unconstitutional on other grounds, but all convicted felons who were convicted of a violent crime who have now been released back into society and live in a home with 2 children under the age of 10 shall receive a state-issued firearm to have in their home. Okay, there you have an outlandish example, right, but it illustrates the point that the state has now affirmatively injected itself into the private sector by affirmatively taking an action, namely arming a convicted felon in their home with young children, right? So we can see how that, at least arguably...
So you can assure everybody in the room that there's no risk that the General Assembly and the governor is going to sign into a law to enact Pennsylvania's version of the purge.
I think that's right, Your Honor.
Okay.
I think that's right. But, you know, that's the distinction, and I know that's an extreme example. That is an example of the government proactively involving itself in private conduct in a way that causes an increased risk of harm. Here we have a scenario where even if you accept the characterization that petitioners have presented as true, the government is just saying, we're going to not allow local governments to try to protect people from harm through ordinances.
Okay.
That's a different animal. And
Do we have other questions from the bench? Do you want to sum up, please, Mr. Holtzman?
Yeah, Your Honor, again, back to my fundamental point, there is no affirmative state action here. There is no evidence, or I should say no pleading, that the statutes at issue actually caused any harm to an individual petitioner or caused someone else to cause harm to an individual petitioner. There is no right to have the government protect you from private acts of violence. And for these reasons and the others I've articulated today, the Commonwealth Court was correct in dismissing the petition for review.
Okay, thank you. Let's hear from Mr. Mullen, although I'm not sure what is left to say. You can rest easy, Attorney Ahola, that it takes 3 attorneys on this side to counter your one argument. Go ahead, Mr. Mullen.
May it please the Court, my name is Daniel Mullen. I'm with the Pennsylvania Office of Attorney General. I represent the Commonwealth in this matter. I'm going to address substantive due process. Hopefully I'm going to be covering some new ground. But I want to just very quickly make clear at the outset that the Office of Attorney General absolutely appreciates that gun violence is a serious problem in this Commonwealth. And in fact, we are at the forefront of trying to address it. We are aggressive when it comes to prosecuting gun crimes. Our gun violence task force has seized thousands of illegal guns and made thousands of arrests. But what we're not willing to do is go along with an effort to essentially upend the structure of our Constitution.
So you agree there are laws there are laws on the books state and federal, that the Office of Attorney General can enforce to address gun violence?
Absolutely, Your Honor. Yes. But again, what we don't think this court should do is contort certain legal doctrines so that the appellants can get rid of a law they dislike as a matter of policy. And we think their substantive due process right is especially problematic.
Well, let's go back just one moment, because
Yes.
that verbiage troubled me. It's not a law they dislike. They have a legitimate and sincere concern about protecting lives in Philadelphia.
I don't dispute their concern is genuine, Your Honor. But what I was trying to say is that they're essentially asking the court to weigh in on a policy matter, and that's our concern. And so the problem with an individual right to, quote, collectively enact legislation at the local level is that it would be completely unworkable in practice, as some of the questions have indicated. Each municipality, or rather the people of each municipality, are going to have dramatically different views about what constitutes a life-saving gun ordinance. In Hopewell Township, for example, and we cite this in our brief, they've already enacted what they have labeled a Second Amendment sanctuary ordinance, which purports to nullify state laws that restrict access to a firearm, because in their view, a life-saving gun ordinance is any ordinance that removes barriers to accessing a firearm. And so, Justice Probst, you were asking, like, what's the yardstick? How does this play out? It's going to inevitably mire the courts in making policy judgments. This ordinance makes sense. We think it saves lives. This one doesn't. They don't identify a metric for how courts are going to go about making that assessment. And so that is the concern of the Office of Attorney General, and we think that it would extend beyond the realm of gun control as well, and would conceivably require the enactment of other policies that somebody might label as life-saving or necessary.
Well, isn't the point in that regard that given, this is Article 1, Section 1, inherent rights of mankind, and the rights are inherent, not only inherent, but indefeasible, meaning they cannot be defeated. So, and that includes enjoying life, pursuing their own happiness. So isn't the point then that if appellants prevail, we and the lower courts in Pennsylvania will be refereeing claims of when particular legislation has defeated or impaired those rights of enjoying life and pursuing happiness?
That's exactly the concern.
And that goes to my question about the metric or the rubric. What is it?
Right. And I didn't hear one identified by my friend. And again, I think it will inevitably mire the court in policy questions and could conceivably require the affirmative enactment of other certain policies. You know, I was reading in the Atlantic magazine just the other day. There was an article talking about how social media has not only led to an increase in suicide amongst teens, but has actually led to an increase in murder, and they were talking about a case in Philadelphia. And so I think the extension of my friend's theory of the Constitution would be you're entitled to the enactment of a ban on social media, at least at the local level. And so that is our concern about identifying this very amorphous right to collectively enact life-saving policies. Justice White, you said, where does it end? And again, we didn't hear a particularly good answer on the other side.
Counsel, suppose it was only individual plaintiffs asserting Article 1, Section 1 rights.
Yeah, I think absolutely, as has been discussed already, the city of Philadelphia doesn't have Article 1, Section 1 rights. So, yeah, I think they're a step closer, but I don't think they have identified a constitutional right in the first place. So, yes, it absolutely extends to individuals, Article 1, Section 1, but it doesn't encompass a right to collectively enact any particular policy.
But suppose it was an individual challenge to the constitutionality of preempting the field based upon the specific needs of identified municipalities or groups of individuals who live within those municipalities. And I keep hearkening back to the notion that regardless of how gun violence has spread, the strength of the problem, the true tsunami of this problem, is in communities where minorities reside. So, what do you think? I mean, is there an Article 1, Section 1 right to be advanced by individuals in those circumstances about the preemption of the field?
I don't believe so, Your Honor. And again, I think it's tricky to say we have an Article 1 section right, but only if you live in certain areas.
But I believe your colleague just made a good point, that fundamental rights need to be uniformly available across the state of Pennsylvania. So if a fundamental right, assuming there is one, to life and liberty exists, then people in certain neighborhoods or communities in Philadelphia or Pittsburgh certainly have the same right to pursue life and liberty as individuals in more rural counties.
They absolutely have the same rights, Your Honor. But to Chief Justice Todd's point, the solution is through the political process and through the democratic process, and to elect new leaders if you don't like the policies that they've enacted.
But is that true? And I'm just probing the issue with you, because if there is a fundamental right that an individual could pursue along these lines, why can't that individual bring a constitutional challenge to laws that preempt the field in terms of communities in which they reside being unable to react to local conditions that affect them and their rights individually?
I suppose it's well, one, I do not necessarily agree with the premise that we have an identifiable constitutional right here, but I think it's sort of a line-drawing question about sort of when exactly does the right kick in and what's the threshold, and I think
well, that's the challenge.
Yeah.
Because if that right were identified, then the protocol is fairly simple, because if it's fundamental, we have a procedure that we follow in terms of determining whether or not the right has been infringed. So, I mean, but the issue is identifying the right, and I think we're in agreement that individuals probably have a stronger right in that context versus a collective right housed in their municipalities.
yeah, I would agree with that, Your Honor.
Any other questions for Mr. Mullen? Do you want to sum up, please?
Yes, I'll just once again reiterate that we appreciate the problem, but we just think that our friends are respectfully in the wrong forum for trying to address it, and we would ask that you affirm the Commonwealth Court.
All right,
Thank
thank you. I just want to say that all counsel gave a tremendous argument today, and your clients were all well represented. I also wanted to comment on the briefs. They were excellent, and in particular, the amicus briefs. I believe we had 8 of them. The court really appreciates amicus briefs, particularly when they're well done. They're very helpful to the court, and in this case, they were excellent. So just wanted to mention that as well. We're going to take our lunch break now, and Mr. Minner will resume at 12:45. Good afternoon. I see that we've cleared out the courtroom quite substantially from this morning. Would you call the first case, Mr. Minner?
Pennsylvania Labor Relations Board and Abington Heights Education Association versus Abington Heights School District, representing the PLRB, Ms. Carolyn Sargent, representing the Education Association, Mr. Jeffrey Sissian, representing the school district, Mr. John Hyde Jr.
In this case, Abington Heights School District entered into a dual enrollment agreement with a local college which allowed the district's high school students to take courses at the college for high school credit. Although some of these dual enrollment courses were classes that traditionally had been taught by the district's teachers, such as English and business classes, the district did not bargain with the teachers' union over the use of college employees to teach these courses. We must decide whether the district was required to bargain over this program pursuant to the Public Employee Relations Act.
Excuse me. Good afternoon, Chief Justice, Justices of the Supreme Court. May it please the Court, my name is Carolyn Sargent. I am here on behalf of the Pennsylvania Labor Relations Board. Co-counsel here is Attorney Jeffrey Sissian. He's here on behalf of the Abington Education Association, and he is for Pennsylvania State Education Association.
Will you both be arguing?
Yes, and I was going to tell you how we're going to divvy up the arguments. So I will be talking about the removal of bargaining unit work and the case law that deals with that. I also will be talking about, when you look at section 1525 of the public school code, whether that actually explicitly and definitively prohibits bargaining over this issue. Attorney Sissian will be discussing the differences between section 1525 and Act 46. They both deal with dual enrollment programs under the school code, and the Department of Education's interpretation of both of those provisions and how to set up the dual enrollment programs under them. He will briefly talk about deference to the board's expertise, and then he will also discuss the amendments that happened after, the amendments to section 1525 that happened after our decision was rendered.
I'd like to ask you at the outset, counsel, isn't this all moot now? I mean,
so no,
it doesn't really matter anymore, right?
So concerning whether 1525 prohibits, preempts, arguably maybe it's moot. However, the real issue that is important to me is the Commonwealth Court's decision concerning the differences between the managerial interest of the school district and their educational policy trumping the teachers' rights to not lose their bargaining unit work without the school district first bargaining with them.
But wasn't that confined to this particular old landscape that no longer exists?
Well, I would argue that the court's decision could apply to any case dealing with a school district's educational policy, not just in a dual enrollment situation, but that moving forward, school districts would say, hey, per this Abington case, we have an educational policy, therefore we can just assign this work to whomever we want. And so that's why I'm here today, because I really feel that's an important aspect of this decision that needs to be overturned because it's contrary to decades of case law concerning removal of bargaining unit work.
Please proceed.
So the issues in this case, the first issue, did the school district violate its duty to bargain when it entered into this dual enrollment program and assigned college professors to teach courses for high school credit? I submit to you that, yes, they did violate their duty to bargain. The other issue is, okay, so now we have to look at it in the standpoint of the dual enrollment program and section 1525. Does that section prohibit, explicitly and definitively, prohibit bargaining over who will teach these courses for high school credit? And I would submit that no, it doesn't.
Are you distinguishing, I'm sorry, are you distinguishing between courses that the high school offered and courses that the high school did not offer but were offered at the college level?
So What I would say is the courses that the college offer were the same type of courses that the high school was offering.
Some of them were.
I'm sorry.
Some of them.
Some of them, the English, the math, the business education, and some of the vo-technical classes. And so really what the board was looking at was the program concerning the high school credit. The board was not saying that they couldn't have this program so that the students could go to the college and get college credit for these courses. What we were saying is if they wanted to also give high school credit for it, they needed to bargain with the union first over who would actually teach courses in this situation.
And did that argument only apply to courses that the high school already taught?
Correct. There was a finding that the courses that were in this program were the same as the courses that were in the high school curriculum book. So those are the courses we're focusing on, is the courses that the high school would have taught as well.
Gotcha. Thank you, Mr. Justice Brobson.
That's, so I kind of want to delve a little bit more into that, because I'm trying to understand how bargaining unit work was removed. Because, and I know there's an effort to say, well, these are, in response to the Chief's question, they're the type of classes, but they aren't college-level classes. They're high school-level English, high school-level business. The classes that are being taught by the college are college-level and English and college-level business, right?
Well, so I would let Attorney Hussisian maybe be a little more knowledgeable about this, but there's nothing in the record to show that the college-level courses were any different from courses that I believe the high school has, like advanced placement courses, college prep courses. So there was no evidence that, like, the college courses were better than the high school courses or different.
Well, there's no evidence that this college is teaching a high school level course either.
Well, it's the teaching of courses for high school credit.
Well, but so you're not saying that you could bargain over the students enrolling in college.
Oh, no.
They're entitled, the statute says that they can enroll in college and have these dual enrollment arrangements. And you're not arguing that your teachers, their bargaining contract entitles them to teach college courses at any university.
Well, so I will step back a little bit on that one. So it depends, and again, I hate to say it, Attorney Hussisian is going to talk about the numerous ways under Section 1525 you can set up a dual enrollment program, and one of those ways could be where the high school teachers are actually teaching the courses for college and high school credit. And actually, in this case, in Abington Heights, they do have a program like that.
Right, and I think the board's opinion on that doesn't really explain that program very well. We had to kind of go into the record to realize, and the key difference is this college, Lackawanna Technical College or something,
just Lackawanna College,
went through the high school curriculum and picked out courses and said, oh, if you give us $100, we'll give you a college credit for that.
Well, and you're correct that the record doesn't have much detail about the Lackawanna College dual enrollment program other than that the teachers in the high school are teaching those.
Well, it also has what I just said, right? Because it is in the record what that dual enrollment program is. It really, all it was Lackawanna College getting money.
Well, I'm not really sure. I will take your word for it. I'm not really sure how that program.
But this is a different program. This is a program that allows students to go to college early, to get a college education, not a high school education. It's not, and you have to concede that your bargaining unit, unlike the Lackawanna County situation where they were teaching high school courses and they were always teaching high school courses, can't teach the courses that are being offered by this college or university.
So in this case, the board was not holding that the high school teachers could teach the college courses. Obviously, under the dual enrollment situation, that's not how it's set up. And in our situation, we weren't saying that the high school teachers could teach the college courses. What we were saying is if the college professors are teaching courses and giving high school credit.
Well, okay, so I'm going to focus on the credit because that's what you're focusing on.
Right.
The statute says you can use the credit at college toward credits toward graduation, right?
And that is one way to set up that.
Right.
dual
It
enrollment.
doesn't say that toward credits on a particular course being offered by a teacher of the bargaining unit.
Well, and I will say, with our removal of bargaining unit work concerning teachers, it's not the specific course that's taught, it's the teaching and assessment of students. So in this case, as Chief Justice Todd said, the courses were courses provided by the high school teachers, but it was also they were teaching and assessing these high school students for high school credit.
Well, isn't that traditional, though? I mean, not this precise type of agreement, but high schools routinely offer advanced placement courses, and if a student takes the advanced placement literature or advanced placement history or whatever it is, and passes an exam at the end of the semester with a certain score, then that is potentially useful as college credit for the student if the college they're attending accepts it. Isn't that the case? And that doesn't seem to be unusual, that aspect of it.
Yeah, I do believe so concerning the AP courses, the advanced placement courses.
But here we're talking about students, high school students going to college and taking college courses, not taking AP courses offered by the teachers where a college might accept it. That's more of the Lackawanna College
Well, but
situation.
it's applicable here, isn't it? Because if the teacher could teach that kind of a course, and that's the course that the college is going to teach, then it seems like the teacher has a pretty strong objection. Why aren't you taking that class? And the union would have a strong objection. Why aren't you taking that class in the high school?
I guess because the student wants to go to college and the legislature is letting you go to college, right?
So
We'll figure this
well,
out.
So based on your questions, I think the real issue is how is the school district permitted to set up these courses? Do they have discretion? Can they bargain over it? Or is it they have to have the college professors teach these classes? I think that's
Well,
what the
but you answered my question. The high school students, the high school teachers can't teach these classes because they're not qualified to teach these classes. They're not members of the faculty at the colleges. Are you suggesting that, I mean, what would the bargaining look like?
So I do believe that in the public school code that the high school teachers can teach these courses, but they do have to have some certification. Again, I do believe that Attorney Husissian has a little more detail on Section 1525 concerning that. That's the main argument with him, is the duality, the differences between the programs and how they can be set up.
So the bargaining would be, we will allow you to enter into an agreement with Duquesne University on dual enrollment, but you have to require Duquesne to hire our students to teach this course.
So the bargaining would be, if you're going to have these courses for high school credit, you need to bargain with us first over whether the college professors can teach those classes or whether it should just be set up as college.
Well, doesn't the
credit.
college decide whether they can teach those classes? The college hires them.
Well, so in this instance, and this goes with the whole difference between Act 46 and 1525. Act 46, which is the other section of the school code that can help you set up a dual enrollment program, that one put the decision of who the teacher is in the college. Under 1525, the Commonwealth Court below and the school district below both agreed that 1525 puts that discretion and decision with the school district. So the school district decides.
The college might say otherwise.
Well, and you're certainly correct. The college could say otherwise, but the discretion's within the school district how they want to set up this program and who they want to teach the courses, at least for high school credit. I want to stress that it has nothing to do with the college. That's certainly a beneficial thing for high school students to be able to go to college while they're still in high school and get some credits towards that. We're just really focusing on the high school aspect of it.
But the General Assembly and statute said that they may get credit toward graduation for that. So again, and I'll stop, because you're not, I don't think your answers are helping me understand. I'm not against bargaining if there's a result that can be achieved, but the General Assembly says these students are entitled to go to college. They're entitled to go to college, and college is taught by college employees. At least every understanding that I have is that that's how it works. And then the General Assembly says they can get or may get credit. And therefore, you're going to say, we will let them go to college, we will let them be taught by professors, but in terms of the may get credit, we want to bargain over what? Whether they get credit or don't get credit?
It would be specifically the high school credit. And
So how would that bargaining look? You don't want them to get the high school credit because you want them to attend the high school class. Is there middle ground that would be bargained through some, I mean, how would that work?
So, looking at this, I mean, it's bargaining, well, let me back up. They can bargain to a bona fide impasse. We do have our subcontracting case law, where it's not that the employer cannot subcontract the work. They need to bargain with the union over a bona fide impasse, and once they reach that and they go through all the bargaining steps, then the employer could actually implement their decision. So in this instance, it would be the school district would have to bargain with the union to a bona fide impasse, go through all the bargaining steps per our statute, and then once there's a bona fide impasse, then they could have the college professors teach these courses.
Does it make a difference if the college credit isn't awarded to the student until and unless they attend the college in the following fall?
So I did look at that aspect of this particular program because the students won't get this credit unless they actually attend the college. So then I wondered what was the benefit of going if really all they're getting is the high school credit. And it seems like it's not for the college, it's for the college credit, it's just that's separate and apart from the high school credit, that it's more set up just to get high school credit.
And so, and just to make it clear, the concern that you have is that the school district will say for some reason or no reason at all, hey, we don't need those 4 English teachers this year because we're just going to ship our students over to Johnson College and they'll get the credit there, so they're out of the picture.
That's correct. That is the concern that the board does have. That if you let them do that, they'll just systematically chip away the unit work, and then eventually they won't have the, like you said, the English teachers. They'll just have the college professors teaching.
Just for clarification, share with us what your perception of the violation and how it could be corrected.
So the violation here was that the school district didn't bargain prior to having the college professors teach these courses and giving high school credit to the student. The remedy in this instance, at this point, the agreement, I believe, is expired. But what the board ordered was to put the work back to the unit, specifically the teaching of the high school courses, not the college courses, to rescind the agreement with the college and to make any unit members whole if there were any unit members that had like a demonstrable like impact on it. So that
were there any such teachers?
So the teachers were still teaching their courses. There were less students in their classes, and I know that the Commonwealth Court below made much about that fact that they couldn't find an impact because the teacher was still teaching the classes. However, that decision's contrary to the Commonwealth Court's own decision in the City of Harrisburg case. In that case, the City of Harrisburg had the police officers issuing citations in their parks. Well, they created a park ranger program and permitted the park rangers to also issue the citations. In that case, the city said they didn't lose work. The police are still issuing citations. We just have park rangers issuing citations as well. And I just want to quote from that case what the Commonwealth Court said in response to that argument. It said, contrary to the city's argument that all of the officers' former duties remain intact. The rangers are issuing citations which police officers would issue if the ranger program had not been established. Obviously, because the rangers are fulfilling some of the former duties of officers, the officers are not doing all the work for which they bargained. Thus, the unit lost work, and there was a demonstrable impact on the unit members. I look at that as like a de minimis standard. Well, they're still teaching the classes. They just lost a few students. It's not that big of a deal. But the problem is, number one, the board has never permitted a de minimis standard, and this is why. A de minimis standard, how far do you draw the line? Is it 5 students, 10 students?
Well, isn't it more than that, though? Isn't it even how much funding the school might eventually get based on how many students it had in each of its classes? Doesn't it have more far-reaching potential impact?
So I don't know about the funding, but the impact with allowing the school district to, or allowing the Commonwealth Court's decision concerning like a de minimis standard to stand, is that all that will do is permit the school district little by little to chip away systematically at their bargaining unit work and argue, oh, it's our educational policy, it's just a little bit, they just lost a few students. When in reality, in the future, the bargaining unit members, oh, we don't need this many teachers anymore because now we've removed the work. So that's the issue with the de minimis standard, and that the Commonwealth Court's decision is contrary to its own decision in the City of Harrisburg case.
How does your position and the statute mandating, because it mandates now, mandating schools to create dual enrollment programs, how does your position and the how can give me an example how they coexist? Because again, I still don't understand how you're going to get universities and colleges to hire high school teachers. I just don't see that happening. I bet you the faculty unions will have a cow about that. So tell me how the statutory mandate of requiring to give high schools the opportunity to attend colleges and take college courses and your requirement that they bargain coexist.
Are you talking about the amendments or the way the statute was at the time of the?
Well, I'm talking about them both, but I guess I'm sort of now that your agreement is moot and gone, we're dealing with a new statute, but it used to be may, now it shall.
Right.
But how is that going to exist without the very concern that you're raising, which is this idea that some unscrupulous school board somewhere is going to require all their enrolled students to take college classes and avoid teaching school?
So my reading of the statute at the time that it existed when we had our case is a little bit different. You said that it permits them to get the high school credit at the same time for the college credit. I actually read that when it says the agreement may be structured so that high school students may receive credit towards completion of courses at the school district, I read that to mean that the high school students can still go to the high school, take their courses there, get their high school credits, but then they can also go to the college to get college credits for those courses. And please correct me if I'm wrong, your interpretation is more when we create these programs, the high school students can get college and high school credits for those courses.
That's what I believe a dual enrollment is designed to do, right? Isn't that to attend the college and get college credit?
To attend the college, and certainly for them to get the college credits, but I read this as saying you can do it a number of ways. Certainly you can do it college credit and high school credit for the college courses. You could do it college credit only, which the school district did have that at the University of Scranton. It was college credit only, no high school credit. You could do it where it's college credit, but then the high school credit, the students just go to the high school, take the courses at the high school for that.
So okay, again, to wrap it up then, your point is if the program is structured, which the General Assembly says it may be structured, to allow the attendance at this college and getting this college credit to satisfy a graduation requirement at the high school, you have to bargain over that aspect. And then I go back to, it's pretty much a binary choice, right? Either they can get credit or they can't get credit. There's really nothing else to bargain over.
Correct.
Okay.
The bargaining would be, if they get high school credit, will it be the high school teachers?
Well, it's not going to be the high school teachers.
Right.
They're either going to have to attend the high school class, or you're going to agree through bargaining, or an arbitrator is going to decide that they can get the credit without attending the high school class. And you're going to leave it up to individual arbitrators, and we're going to have a mishmash of decisions on that.
Or they could set it up the way the school district set up their Lackawanna College one. Obviously, like you said, the college would have to be in agreement over that, but it is possible, it is an option.
Counsel, I'm a little bit confused because you seem to be conceding the point that the statute at issue in this case contained a mandate. And my understanding is, and as I read it, it does not contain a mandate, and if it doesn't contain a mandate and the topic is otherwise bargainable, then it's bargainable. In order for a statute to preclude bargaining, it has to specifically and definitively instruct the district to do something. And this statute didn't. Therefore, the bargainability of this work remains on the table. Is that not right?
So I apologize if I made this confusing. So in answer to your question, Section 1525 does not mandate that it has to be the college professors for high school. It doesn't explicitly and definitively say you cannot bargain.
That's your whole case, isn't it?
Well, so that's part of the case. The first part of the case was that the Commonwealth Court said this was a managerial decision and ignored the case law, decades of case law concerning removal of bargaining and work. The second part is, what does this statute mean? So in that case, the statute doesn't prohibit bargaining over who will teach the courses for high school credit. All it says is that the school district can enter into agreements with colleges in order.
I understand that.
Yeah, right.
It says may enter.
May, yes. At the time it said may.
That's I'm confused because the entire former line of questioning was based upon the premise that the statute at issue mandated action, and it does not. Because if it did explicitly remove the district's ability to do anything other than let these students get college credit at colleges from courses taught by college professors, you wouldn't be standing here because they would have removed the topic from the bargaining table by creating that mandate. Isn't that what the Commonwealth Court's precedent stands for?
So the Commonwealth Court relied on the notwithstanding any other provision language to say that this statute precluded bargaining. And really all that notwithstanding means is, notwithstanding any other law, the school district can enter into dual enrollment agreements. It doesn't explicitly these classes.
Well, that's the point.
Right.
Notwithstanding anything to the contrary means nothing when the rest of the statute is still written in the permissive context.
Right. So you're correct, Your Honor. This statute doesn't preclude bargaining over who teaches these courses for high school credit.
So if I understand it, all you wanted to have happen is bargaining to impasse, and then the school districts could have done exactly what they did that you're complaining about here.
Under our case law, if the school district had bargained to a bona fide impasse,
Well,
yes.
what if the arbitrator ruled your way and said, no, under this dual enrollment program, our bargaining unit members have to teach those college classes? And the college said, yeah, no. We have a faculty union ourselves, and our faculty union doesn't want anybody outside of the union teaching these classes, so no.
So when you say arbitrator, are you speaking like that the parties are going to like binding arbitration? I guess I'm trying.
Impasse arbitration. You go to impasse, you bargain good faith, you go to impasse, you have an arbitration, and the arbitrator rules in favor of the union and says, no, if you're going to have this program, the teachers have to teach these classes for college credit.
Well, I think the school district would then have the opportunity to appeal that decision up through the courts. And
I understand that, but I'm saying let's assume they do and it wins. how does that get enforced short of the school not being able to enter into the agreement?
They could still enter into the agreement to have the college courses for college credit, which honestly is
See, that's
the important.
I'm glad you said that. I'm glad you said that because I think that brings us back to the point. Your issue is not that you want to bargain over who teaches the college course. Your issue is you want to bargain over whether the high school student gets credit toward graduation from high school through the college course. So you're not bargaining over who teaches it. You're bargaining over the question of whether the student can all get high school credit.
No, it's still over who teaches the class, because the high school credit is part of it, but you can't have non-bargaining unit teachers teaching courses for high school credit. So it goes together. It's not separate. There would be no reason to just separate the credit part of it, because you don't get credit unless you have the people teaching the classes. So the teaching of the classes is the main part of it.
Well, and there wouldn't be an issue, would there, about whether to bargain or not, unless the high school teachers felt they were losing something. They were losing the opportunity to teach that class.
Correct. That's what happened in this case is, like I said earlier, if you permit them to just systematically chip away, the teachers would then, in a future point, they would just lose the work altogether. And so they wanted to assert their right to bargain over who's teaching these classes for high school credit. They know it's a college. They know it's in a dual enrollment setting, but they feel and they believe that that's their work, and they should be able to bargain over whether they get high school credit or who's teaching it for high school credit.
Well, and it didn't really matter if ultimately it would go down to zero. The chipping away could be, well, the high school English teacher lost 2 students this year. Next year she may lose 5 students, and then instead of having 2 classes a day, she's going to have 1 class a day. It can incrementally go down. Even if it never goes to zero, it could still hurt the teacher in terms of the teachers' union's view.
Right, and when doing the balancing test concerning removal of bargaining unit work, this court, the Commonwealth Court, and the board have all said that the interest of the members in retaining their work outweighs any employer's interest in using a contractor or a non-bargaining unit person to do the work. That's what's happening here. The bargaining unit members want to retain their work, and by permitting the college professors at Johnson College to teach courses for high school credit, it's taking away their work, even if they're still teaching that class, because any removal.
Even if who's still teaching?
Yeah, I'm sorry, even if the high school teachers are still teaching English or math or business education, they're still losing work because someone else is also teaching that class who's not part of the unit.
What about if the program allowed students to take a college class that just wasn't offered by the high school, like nuclear physics 1, and you had some brilliant kid in the high school who wanted to take it? That's not an issue to anybody, is it?
Oh, no, because the union has to prove they exclusively perform the work. If it's a course like physics like that, and it wouldn't be an issue.
The teachers at all.
Right.
So it's a subject matter test.
Well, so it depends on whether they've proven that they've performed the work. The work is teaching and assessing students. And the board has said that it's not specific courses, it's the teaching of the students.
Okay, let's see if we can wrap it up.
Okay.
Any justices have any other questions? You want to sum up?
Yes, sure. So decades of the case law from the board, the Commonwealth Court, and this court support the board's decision that removal of bargaining unit work is a mandatory subject to bargaining, and that the school district in this instance violated its duty to bargain under para when it used the Johnson College employees to teach courses for high school credit. Permitting the school district, as found by the Commonwealth Court, to transfer this work to these college professors under the guise of educational policy is inconsistent with your honorable court and the Commonwealth Court's decisions and contrary to the requirement under Section 701 to bargain over mandatory subjects. Further, Section 1525 of the Public School Code doesn't explicitly and definitively prohibit bargaining over who will teach these dual enrollment courses for high school credit, and therefore bargaining over the issue wasn't precluded under Section 703 of PARA. Therefore, the board requests this honorable court to reverse the decision of the Commonwealth Court and to reinstate the board's final order. Thank you.
Okay, thank you. Let's hear from Mr. Hassisian.
May it please the Court, Jeffrey Hassisian here on behalf of the appellant. I'm with the Pennsylvania State Education Association. I represent the Teachers Union of the Abington Heights Education Association, who is the complainant in the Labor Board proceeding. Ms. Sargent has already discussed the bargaining issues under Act 195. My role today is to address the dual enrollment laws in the school code and the errors that the Commonwealth Court made in interpreting those laws. A bit of background, there are two pieces of legislation we need to keep track of here. The first appears in Article 15 of the school code. It's 24 PS 15-1525. It was passed in 2004, and it gave school districts the general authority to establish dual enrollment programs. The second law is Act 46, which is in Article 16B of the school code. That was passed in 2005, and what that does is it sets up state funding for certain dual enrollment programs that meet the specific requirements of Act 46. And what that law basically says is that if you're going to get state funding, you need to meet all the requirements that appear in Act 46. And those requirements are approval by the Department of Education, funding, you need to disclose the number of students taking it, their annual reports, and importantly, college faculty have to teach the classes, and it is the college or the university who makes the decision who is going to teach it rather than the school district. So those are the unique requirements of Act 46. Now, in this case, there is absolutely no dispute that the school district did not get state funding for this and did not proceed under Act 46. It was stipulated and admitted to at the hearing by the superintendent that they got no state funding whatsoever. The no state funding is coming in because of this program with Johnson College. They followed none of the process and procedure of Act 46, and none of it applied at all. So Act 46 does not apply, and that is a key issue in this case, because the language requiring college faculty applies only to state-funded courses, and because it doesn't apply, the Labor Board looked at the other law and said there's absolutely no language in here that prevents the teachers here, the bargaining unit, the high school teachers who are members of our bargaining unit, from teaching this class. And in fact, on the record, because there's a long-standing past practice of our union teaching all high school classes, even newly created classes, new curriculum, including another dual enrollment program that this school district had going and continues to have going for several years with Lackawanna College. It's the same program. The students receive both high school and college credit, yet our bargaining unit members perform and teach those classes at the high school.
But they're not teaching college classes. In that Lackawanna College example, Lackawanna College went through the high school class curriculum, checked the boxes of high school classes that they said we will accept as credit for if you pay us $100 per credit.
Well, respectfully, Your Honor, the Labor Board issued a hearing on this and found that the Lackawanna College program is another dual enrollment program that is used for both high school and college.
I'm not saying it's not. I'm saying, though, in that case, the college is giving credit for completion of a high school course. This situation is how the high school is giving credit upon the completion of a college course.
Your Honor, the record shows absolutely no distinction between the current program with Johnson College and what has already happened with Lackawanna College.
I know, because the board didn't, but you have to look at the record, and the record includes the program from Lackawanna College and a description of the program, and what I'm describing is the program, and that's in the record.
What my understanding of the record shows is that students who take those classes through the Lackawanna College receive both high school and college credit at Lackawanna College. Should they attend college?
Respectfully, I think you're wrong. They're not attending Lackawanna College. Lackawanna College looked at the high school program classes, CP English, and said, hey, we will give you college credit for that high school course that you're taking at your high school if you give us $100. If you don't think that's what it is, then I'm not going to have an argument with you, but I think that's what the record shows.
Well, I think the record does show, as we both acknowledge, that the students receive both high school and college classes, and that it has been designated a dual enrollment program by the Labor Board. But the rule of
The bottom line is here, the concern of the union is that the teachers, the high school teachers, are getting fewer classes to teach because of this program. Is that correct?
Our concern is broader than that, actually.
I thought I had it all figured out.
No, our concern is that whenever there is a diversion of bargaining unit work, and under the law of the Labor Board and case law, when you represent a teachers union, you represent all classes that are used towards high school credit, including newly created classes. So we actually have a case in our history where the Abington Heights School District created a new class, Mandarin Chinese, which no one taught. Now, having an outside college professor come in and teach that course did not impact any of the existing union members at all, because none of them taught it. Nevertheless, the Labor Board ruled, and the district never appealed, that that was a diversion of bargaining unit work because that was a newly created course that is being used for high school credit, even though the curriculum never existed before. So here we have dual enrollment classes, and even if we were to assume for the sake of argument that it is somewhat different from what already happened at the Lackawanna College dual enrollment program, the fact of the matter is that these courses at Johnson College are being used for high school credit. Therefore,
to the detriment of high school teachers.
Potentially down the road, but you don't, the Labor Board is, even a de minimis impact is actionable. You don't need to show that any of the existing bargaining unit members have lost any jobs or work hours or pay. Otherwise, the rule, what would happen would be that a school district could, for example, create a whole new building and then outsource all the new teaching jobs, saying, well, the existing union members aren't being hurt here, so we can do this, and that is not how the law works. Even if there's no impact, if none of the existing union members have lost any money or any work hours and are not financially impacted at all, it is still an injury to the union because it is a loss of bargaining unit work, which includes all high school classes, even newly created ones that are used for high school graduation.
But suppose there's a detriment to the students. We don't care about that.
The district put on absolutely no testimony on that.
Well, I mean, let's just think it through.
So there's no basis to assume that.
Let's just think it through for a minute. A student can get college credit for a college course that encompasses much more sophisticated, much more detailed analysis of English literature, the use of English language, et cetera, et cetera, et cetera. Or they could take the high school course that does none of that.
Well,
some would argue on the face of that, that the student may be in a better position if they were taking the actual college course for actual college credit and high school credit.
So, Your Honor, that's the school district's argument, that they're assuming that the courses are automatically better if they're simply taught by college faculty. The fact of the matter is, whether college faculty teaches it or high school teachers, it is the same curriculum. It is the exact same educational program, the same
Where's that in the, really?
Yes.
That your high school is teaching in college level classes?
It's the same curriculum that is later being accepted by the college for credit. It's the same. It's the same curriculum that's accepted for high school credit, and then it is used for college credit should the student then enroll in college. It is the same curriculum.
Is that because they're AP or CP classes? You're not suggesting that a basic 10th grade high school English class is comparable to a college English class?
Under 1525, the agreement that is entered into between the school district and the college would stipulate what type of level of excellence students would have to enter the AP program, which I believe was one of the aspects of the dual enrollment program here.
Is that different from AP?
Excuse me?
Is that different from AP classes?
AP classes are a little different, but it's the same principle because they are both used for both high school and college credit.
But it wouldn't be limited, you're saying it wouldn't be limited to the AP classes?
Correct. Excuse me?
You're saying, counsel, that it would not be limited to the AP classes?
No, our dual enrollment is also part of our bargaining unit work.
Can I ask you the same question
I didn't understand his answer, Justice Weck.
I'm sorry.
You said, could you repeat your answer to Justice Weck's question?
I think you said it's not limited to AP courses.
I just said that dual enrollment courses are also part of our bargaining unit work because they are used for high school graduation. That's the issue. It's not the college.
Whether or not they're advanced courses in high school.
That's correct.
There's not a third category, in other words. I mean, it's just those two species of classes.
Those are the only two that have come up thus far, if that's what you mean.
Could I ask you the same? Or a similar question that I asked your co-counsel?
Sure.
Why should we decide this case? Isn't the landscape so different now that this decision, whatever we do here, would only relate maybe to some old agreements? Should we await a case under the new provisions?
Well, the problem is that the Commonwealth Court's interpretation of the old Section 1525 could be used as evidence of how to interpret the new law, which now mandates dual enrollment courses.
Do you think that's the case even though the language is so much tighter now?
Yes, because one of the things that the Commonwealth Court ruled upon, seized upon, was the notwithstanding language that was in Section 1525. That language now appears in the new law as well, too. So the Commonwealth Court ruled that the notwithstanding language implicitly prohibits collective bargaining. So we are concerned that a court or an arbitrator or the labor board, what have you, down the road would make a similar ruling because the same notwithstanding language, which, by the way, that notwithstanding language does not refer to the issue of collective bargaining. It refers to the district's general right to establish a dual enrollment class. And under Section 1525, because it's not state funded, you don't have to have college professors doing it. So the fact that the school district has the right to establish a dual enrollment program does not automatically lead to the conclusion that, oh, you can't have bargaining because the high school teachers can't do it. You can have high school teachers do it, as the Department of Education has itself opined.
You can have high school teachers do what?
Teach dual enrollment classes under Section 1525. So our position is
college classes such as AP. Such as AP
yes,
classes.
that would be another example.
Well, but so in your view, the only way a dual enrollment program will work for the union is if the college allows the high school teachers to teach it. If the college says no, we have professors, we have our own union's going to sue us if we give bargaining unit to a high school teacher, you're saying that program just doesn't fly.
There are two ways the school district can do this. One way the school district could have done this is actually complying with Act 46, getting Department of Education approval, getting the state funding, and doing all the bells and whistles and requirements of Act 46. Had they done that, we would not have filed a ULP charge because Act 46 would have applied, and it has that language about you need college faculty. However, the school district did not do that. They did not go through Act 46. Instead, they chose to go under Section 1525.
You're not answering my question, though.
Okay, so
my question was simply, from your client's perspective,
yes.
The only dual enrollment program that would be allowed under the prior regime is one where the college, where they're going to get college credit, permits high school teachers to teach those classes.
Your Honor, by using the language that the college permits it, you are borrowing something from Act 46 that does not apply in this case.
That's fair, but let me ask you, I mean, you got to be fair, too. Are you saying that the high school can tell the colleges it's entering into agreements with that they have to use the high school's teachers to teach a college-level course?
If they proceed under Section 1525 without state funding, yes, it is bargaining unit work. And the district is going to have to negotiate with a union or get the union's permission to use college faculty to do the college classes. As I was
Isn't the converse never going to happen? What Justice Robson is probing, a college is never going to allow a high school teacher to teach a college course for college credit at that college.
Right.
I'm trying to be careful here to make sure that we are not mixing up Act 46 with Section 1525.
Well, I promise you I'm not mixing it up.
Okay, well, as I was saying before, one of the requirements for Act 46 in order to get college funding is this language that it's the college who makes the decision who's going to teach the classes. That language does not apply to Section 1525. If you look at the text of Act 46, you'll see that the Commonwealth Court's reading of the dual enrollment laws goes against the plain statutory language. The Commonwealth Court borrowed the requirements from Act 46 and said that those apply to the program here under Section 1525. The specific language about college faculty teaching it and colleges having the sole discretion on who's going to teach the courses.
Counsel, I understand that. You're missing the practical aspect of this. Yes, in order for you to get funding, the statute says the college has to choose who picks the teacher. I understand that that's what that statute says. But because the other statute doesn't say that, doesn't mean in reality the school district gets to choose who teaches the college course. At the end of the day, the statute says you can have these students enroll and attend a college. And they have to strike an agreement with a college so they can take a college course. And who ultimately has the control over who teaches a college course? It's not the high school, it's not you, and it's not even an arbitrator. It's the college.
Well, Your Honor, in that situation, what you're basically, the college in that situation is basically a subcontracting entity. The union would have the right to block it and say, we have to teach these courses, or you can't do this program unless you proceed under Act 46 and get the state funding and do all the process and procedure.
Right. So the bottom line is no college is going to enter into an agreement because the college isn't going to let a high school teachers union force. You're going to have a fight with the college union.
Your Honor, I don't believe that's true, and there's nothing in the record to substantiate that kind of assertion. They've already done it with Lackawanna College. Lackawanna College was fine with these courses being used as college credit.
Lackawanna College was getting paid to accept high school credits for college.
Well, that would be part of the individual agreement reached between the district and the college under Section 1525.
Counsel, if I might just sort of summarize this the way that I'm understanding the argument, and if it sounds pejorative, I don't mean it to be.
Okay.
But I think what your argument is, this is a subject of bargaining. Absolutely. And unless and until the district bargains with the union over this particular program, the union can prevent it from happening.
That's correct.
Period. And if they do bargain with you, you could still prevent it from happening because it's a subject of collective bargaining.
Yes, and it's the same position we take in any diversion of bargaining unit work case.
I understand that. And when I asked the question earlier, what about the students? Well, the answer is it doesn't actually matter in the context of this argument that we're having here, because what matters here in this case is whether or not this is a subject of collective bargaining. I'm not saying that's wrong. I'm just saying, isn't that what you're telling us?
If the district proceeds under Section 1525,
but that's what
if they
we're
go
talking
under
about
Act 46,
but we aren't talking about Act 46.
No.
I mean, and I understand there's a way to do this that circumvents the problem, but your argument is under Act 1525,
yes,
we are dealing with a subject that's a matter of collective bargaining.
That's correct.
As a result of that, before the school district does anything, they have to engage in collective bargaining with your union.
That's correct.
Unless and until they do, and you come to an agreement, it may very well be that high school students are not getting college credit for courses they take on a college campus taught by college professors, period. And that's okay if that's what, I mean, if that's the stark reality of it, okay.
I agree with that statement if the district is choosing not to apply for state funding under Act 46.
We got that. We got that. We're talking about
Right.
this statute.
So it's not...
What the end of the day is on this is they got to bargain with it. And if they can't work it out, then it's not going to happen.
Unless the district goes through Act 46. Exactly.
Okay, that's fine. I just wanted to make sure I understood. I mean, it's a pretty stark reality and a stark understanding of what it means to have a subject of collective bargaining, and that's not a bad thing. I'm not suggesting that this is a pejorative. I'm just suggesting that's what happens when you have a subject that is one that it requires bargaining.
Yes, but I just want to remind the court that it's not as if the union has the power to completely shut down dual enrollment programs. There's Act 46 where the district can get funding and do it that way. The district decided not to.
I have a housekeeping matter that I'd like you to clear up. You entered your appearance to represent Abington Heights Education Association and PSEA. Is that correct?
Well, I'm a staff attorney with the Pennsylvania State Education Association. I represent the Abington Heights Education Association.
Okay, but you're employed by PSEA.
That is correct.
Okay. On our official docket, your appearance is entered as representing Pennsylvania State System of Higher Education, Office of the Chancellor, Office of General Counsel. That is not correct.
That's not correct.
Okay, well, that has to be corrected. I'm not sure if it was on.
Some additional client is hired.
I don't know, but I was very confused.
That'd be news to me.
Don't be so quick to say I don't represent them.
They may not like your position in this litigation.
No, I don't think they would. So, we will make sure that that is corrected. I'm not sure on whose end that happened, but we will correct that. Anything else? Would you like to sum up, sir?
Well, I just wanted to point out that the Commonwealth Court, when interpreting the dual enrollment laws, borrowed language from Act 46 and said it applied to programs under Section 1525. And that interpretation of the law is against the plain statutory language. When you look at Act 46, it expressly states that the language requiring college faculty and the colleges deciding who teaches the course, which is what the Commonwealth Court applied to 1525. It says specifically that those requirements apply to dual enrollment programs only under Act 46. It says, it uses the term in this article. Dual enrollment programs established in this article, for example, 24 PS 1604B, general rule, a member of an eligible post-secondary institution's faculty who teaches a concurrent course under this article should not be employee of a school entity. And you see that term, this article, and this article is a reference to Article 16B of the School Code, which is where Act 46 appears. The other dual enrollment law passed the year earlier, Section 1525, is under Article 15. It's a completely different article of the School Code. So the plain language of the dual enrollment laws states that that language about college faculty does not apply, and that the Commonwealth Court improperly conflated the standards of Act 46 along with Section 1525. This is also the interpretation of the Pennsylvania Department of Education. The PD toolkit is in the record. The Pennsylvania Department of Education is the agency tasked with enforcing and interpreting and implementing the school code, so its interpretation of the school code, which includes the dual enrollment laws, is to be given substantial deference by courts.
Are you suggesting the statutory language is ambiguous?
I suppose you could say that because the Commonwealth Court, like, for example, used the word attend and said that that was the only sustainable inference. I'm trying to coin the Commonwealth Court's words. The only inference you can draw is that the students have to physically visit a college campus and sit down before college professors. And the Department of Education, who has expertise in education matters, has not interpreted the dual enrollment laws that way. If you look at the PD toolkit, there are several provisions that says that the high school teachers can teach the courses and that often happens at the high schools. It's right there in the PDE toolkit, which the Department of Ed has issued to all Pennsylvania school districts throughout Pennsylvania. So the Commonwealth Court's interpretation that you always have to have the students physically leave the high school and go to the college campus contradicts the determination of the Pennsylvania Department of Education.
Justice Brobson, did you get an answer to your question?
I don't. My only point is I only look to agency interpretations of statutes if a party is arguing there's ambiguity. It's a statutory construction device. So I wanted to know, so you believe the Commonwealth Court's interpretation is a reasonable interpretation contrary to the Department of Education, and we should defer. Okay. Thank you.
That's correct. There's also another problem with the Commonwealth Court's decision in that they gave no deference to the two state agencies, the Department of Education and the Labor Board itself. Now, the Labor Board, as we know, is recognized as the expert in workplace issues in the public sector, and their determinations are binding on the courts unless it can be shown that the Labor Board was clearly erroneous.
Well, you're going to lose me there.
Yeah, exactly. All of us.
Don't argue deference here.
Now, and
Yeah.
I'm certainly not going to accept that anything they do or say is binding on us.
Okay, let's do this. I ask you to sum up, and I think you have expanded your argument. I think we understand your position, and we have your briefs. So thank you very much, Mr. Husisian.
Okay, I apologize. I just wanted to hear my
No,
points,
no,
but I
no,
apologize.
no, I know there's a lot to say.
Okay, well, thank you for your time.
And we'll hear from Mr. Audi.
Thank you, and good afternoon, Chief Justice Todd and the justices. Thank you for hearing me today. If it may please the court, my name is John Audi, and I represent the Abington Heights School District. We know that.
That's clear. Okay.
That's clear, but let's make that clear. This is a very interesting case in my mind.
I'm glad you narrowed
Well, it's
that
not
to
as interesting as the case this morning, but in my heart it is.
Okay.
And I'll tell you why. I'm here to essentially defend the students of Abington Heights from being able to take courses and educational policies that the district puts in front of them without having it taken away from them because of, let's say, a scope of bargaining issue.
Okay, we could posture it that way if you want to, but...
I will.
And that's fine, which makes it very interesting. But, still from a, we have to think about the statute and the law, and matters are excluded from bargaining only where the statute explicitly and, quote, explicitly and definitively precludes bargaining. So where do you find that, quote, explicit and definitive exclusion in this section?
Where I find it is in Section 702 of Act 195, where it talks about a delivery of service being an inherent managerial policy. We sat here and we heard the educational policies, the delivery of service being characterized as many other things other than what they are. They are policies that are put forth by a school board to enhance the education of the students of that community.
Couldn't you say that about anything? I mean, that's quite expansive. If that were the principle upon which this turns, then it seems that you could eliminate anything from bargaining.
No, I don't think that's true. This is a delivery of service. This is, for example, I'll go back because we talked about what would happen if there was a nuclear physicist that was needed to be taught, and what would happen. And of course, Ms. Sargent said that wouldn't be a problem.
Let's hold on a minute. This is how the public watching PCN knows we're not in Elk County.
Can you see that? Yeah. That wouldn't be a problem. Is it okay now to just?
Yes, go ahead.
Okay. And I could tell you, yes, that is a problem. In this very same school district, we lost our Latin teacher. No, you can't find Latin teachers anymore. Thank God. That was a joke. You can't find them anymore. So we had students that had 1 year of Latin under their belt. Well, 1 year of Latin doesn't do you anything to go into a college. So what we did, we found a virtual platform where these students could go, if they chose to, after hours and take their course, their Latin course. So they could say, for credit, they finished 2 years of Latin. We were told we couldn't do that. That was shut down, and we lost at the Labor Board. Next, we needed a Mandarin Chinese instructor. This is an affluent community.
That's spoken by a few more people than Latin.
That's for sure. And, this is a very affluent community, and we have high demands for our students in this district. We interviewed, we advertised for a Chinese Mandarin professor that we were going to hire and be part of the bargaining unit. There was none. We could not find a single person. Well, by happenstance, we came across an exchange person from China who was at the University of Scranton who said, I could teach it for free. I'll do it. That was shut down because that was bargaining unit work. Where is the state college analysis when you have an inherent managerial prerogative of delivering an educational service? You had zero impact on the bargaining unit, no loss whatsoever, and we're told, nope.
But that's not this case.
Can't do that.
In
No,
this
you're
case,
right.
well, see, in
And
this
let me
case,
move to
what
this
is the problem?
case. And let me move to this case.
Yeah.
This is how first of all, I'd like to say that I don't believe Act 46 has a single thing to do with this case. It has nothing whatsoever to do with it.
They would agree with you.
This case,
They agree with you entirely. That was an alternative not
This
chosen by
case-
your wealthy school district. So
this case, yes, and Act 46, I'll tell you, and it's on the record, the state wasn't giving any funding for Act 46. There was no money to be had. So nobody used it anymore. And 1525 was put in, and everybody said, well, that sounds good. I'll use 1525. Now, here's how I, after reviewing what the courts have written about the word notwithstanding. Here's how I would read 1525. Regardless of Section 701, any other provision of the law, to the contrary, so regardless of 701, a school district may enter into an agreement with one or more institutions of higher education approved to operate in this Commonwealth in order to allow resident students to attend such institutions of higher education while the resident students are enrolled in the school district. The agreement may be structured so an institution of higher education approved to operate in this so that the high school students may receive credits toward completion of the courses at the school district and at an institution of higher education. That's pretty clear. We may do it.
it's permissive.
We may. We may.
But you don't have to.
But we didn't have to.
But see,
But-
that's what a mandate is. I mean,
But regardless of Section 701
or 702.
or 703, which says that you cannot bargain over something that is restricted by another statute. So that is in play as well. So I would argue that we did nothing wrong, the district did nothing wrong when it went into and entered into an agreement with Johnson College, a nationally recognized building materials, building program institution, and said, we'll do dual credit. We don't have teachers, as Justice Robson said, we don't have teachers that can offer an associate degree. We don't have that. That's not part of the bargaining unit. We did not take anything away from the bargaining unit. What we did was open doors for students who want to do something different.
You did and you didn't. I'm sort of with you. I say sort of the caveat because I'm still
that's pretty good.
Trying to figure it out. There seems to be two aspects to this agreement that you have with the college. One, and both of which are at least authorized, not mandated, but at least authorized, meaning you're empowered to do it.
Correct.
One is strike an agreement with a college or university so a high school student can attend a college or university for college or university credit.
Correct.
That's one thing.
Yes.
As I understood the arguments of the other side, they don't have a problem with that. You can do that until the cows come home.
News to me, but okay.
I understand, and I may have misheard it, but the issue is the second part of the statutory authorization, which is, oh, and by the way, you may allow that credit to be used to satisfy a credit toward completion of a course required for graduation. And that's where they seem to be saying, and I'm not sure I like their articulation of who may teach the course, but they're the ones that say, wait a minute, under our bargaining agreement, only we get to teach courses for high school credit. And therefore, if you are going to extend high school credit to your college course, you have to bargain over that. And that may mean we win. You can still have the program, but the students can't get high school credit. They can get the college credit, and they have to take whatever high school courses they need to take toward graduation.
Well,
why is that a bad position?
Because 1525 allows us to do that. So it doesn't mandate us to do it like the new 1525 does, but it says, well, notwithstanding Section 701, you may do this.
But that's the problem with the way I think you're reading the statute. Is a statute that empowers a local government
I understand.
to act doesn't mean they can act without restriction. And that's where you say the notwithstanding language is a general wipe away of all requirements to bargain.
Well, it's just not my day today. Notwithstanding any other provision of the law to the contrary. 701 is a law to the contrary. It's as clear as a bell. That's what says you must bargain.
701 doesn't prevent it, though. Laws to the contrary have to be in irreconcilable conflict.
Right, but I don't know that we're not prevented. If we wanted to bargain, we could, but it doesn't mean that we have to. If you read that language, especially in conjunction with 703. That's my point there. That's what I say.
Do you ever want to bargain?
Do we ever want to bargain? We bargain and bargain and we bargain.
Because we have to bargain.
Because we have to bargain, and we don't mind bargaining. But what we don't want to do is get handcuffed every single time we want to do something different for the students. There is no longer, I mean, if there's one thing we learned over the COVID pandemic, brick and mortar school buildings do not exist anymore. What will happen if we're not allowed to change the way we deliver our services, which is an inherent managerial prerogative, we are going to have all of our students run to cyber charter schools and leave us with empty buildings and furloughed teachers. And that is the fear that we have, in addition to the very deep interest at Abington, I can speak for Abington, the very deep interest in providing the very best opportunities for literally every single one of their students. And to be hamstrung time and time again when there's literally no impact to the bargaining unit is starting to make me wonder if we're looking at this properly, if we're forgetting about inherent managerial prerogatives and delivering of those services. Where does it say? I mean, when I read the State College balancing test, when the impact is null, then the balance goes in favor of the delivery of the inherent managerial policy.
Okay, does anyone have any further questions? All right, would you sum up, please?
So my summation is that we would ask that you affirm the Commonwealth Court. We believe that 1525 was properly interpreted. We believe, by the way, it's a memorandum, not opinion, not reported. So the part about the precedent I don't think is really that much of a concern. And we do think that it tackled some of those issues that I spoke about, and we would ask that you kindly dismiss the appeal and affirm the Commonwealth Court. And I thank you so much for your time.
Thank you, Mr. Audi. Thank you all. In this appeal by allowance, we must determine whether Section 8615 of the Pennsylvania Limited Partnership Act, and specifically subsection C18, permits a limited partner to challenge the determinations of a special litigation committee through arbitration, pursuant to the arbitration clause in the partnership agreement. Please proceed.
Good afternoon, Chief Justice Todd, and may it please the Court. My name is Carl Myers from the Stevens & Lee Law Firm, and I'm here today representing the appellants James L. Miller, often referenced as JLM, or the father, two partnerships, MBC Properties and MBC Development, and then their two general partners, MBC Management and Miller Properties Management. And before I begin, I just want to share with the Court that I'm delighted this case has nothing to do with high school credits, college credits, or Act 46.
So are we. Thank you.
But what this case does involve is a fundamental question about the interpretation of Pennsylvania's business organization laws and the need to protect internal business judgment, which this Court has recognized is a cornerstone of our business laws. In the Cooker case, this Court recognized and adopted the business judgment rule. Under that rule, the courts engage in a policy of judicial non-interference in business affairs. It allows the business to engage in its own internal decision-making, and it presumes that a business knows what's best for itself and then protects and insulates it from judicial second-guessing. The law here is the Limited Partnership Act. The Limited Partnership Act is based on a model law, the Uniform Limited Partnership Act. And in Section 8694 of that Act, there's a provision for a function or a tool called a Special Litigation Committee. A Special Litigation Committee is a tool that a business may use as an exercise of its business judgment to form one of those committees in response to a derivative demand. And a derivative demand is basically a claim or a demand by a stakeholder in a business that is asking the business itself to bring claims generally against senior management in the enterprise. It's an optional mechanism for a business to decide what to do for itself with those claims. It's a surrogate decision maker or a help to decide what to do about derivative claims. And it's integral to the business judgment rule. It, again, is part and parcel with helping to protect against outside interference in business decision making. And that is why the Special Litigation Committee statutes provide for a limited court review only in the local court of common pleas when somebody seeks to challenge an SLC decision. In Section 8615 C18 of the Limited Partnership Act, it provides that a partnership agreement, quote, may not vary, end quote, any of the provisions of Section 8694. And this is among a list of 19 limitations that are in Section 8615. The idea being that our business laws want to have predictable rules and ironclad rules that apply to every partnership. And actually, this court, in its Hanaway decision from a few years ago, recognized that there's been an evolution in Pennsylvania from freedom of contract, which used to be in former Section 8520 of the former version of the LPA, to the current version, which is sort of a channeled or sort of more prescriptive version of the Limited Partnership Act. So this is just one of those 19 prescriptions that's found in the Limited Partnership Act. So yes, Justice Brobson.
Just a point of clarification. There was a change in the statute during the course of the litigation.
Yes.
And which version should we be looking at? Because if we look at the version, the earlier version, F only applied if an action was commenced before the determination of the SLC. Now it's before or after. So which version of the statute should we look to try and figure this case out?
This case arose under the former version of the statute, but no party, importantly, no party has taken the position that the court review provision does not apply because of the change in the statute. The change in the statute really was to essentially to clarify what seems to me to be immaterial language in the statute doesn't apply to this particular case. So,
well, no, it does, because I think the problem is, since the arbitration here, the derivative action was commenced after the SLC determination, under the old statute, he couldn't even, you couldn't even go to F, because F only applied if the derivative action was commenced before the SLC determination.
Well, if the court decides that, now, of course, we haven't taken the position that the court review provision is completely inapplicable. Of course, if the court decides that that is the case.
No, I just want to know I want to know which statute to look at. That's the only thing.
The former version, but no party has taken the position that the court review section does not apply. I think the parties actually agree that the court review provisions apply no matter which version of the statute
well, but
is applicable.
I agree with you, and I hate to be a stickler on this, but it goes to your statutory construction argument about it being a court, because F seems to be written in light of the idea that a derivative, the earlier version, the version in effect then, seems to be written with the assumption that a derivative action has been commenced in court before an SLC determination is made.
That's a fair reading of the statute. Now, that's a narrower iteration than we're even asserting. So that would suggest that the petitioner here, the plaintiff here, would actually have to be permitted to have undertaken a derivative action, and then the SLC process happens, and then a court review happens.
That's what the early, as I read the earlier version of the statute, that seems to be what the General Assembly sort of assumed would be the normal process. I don't think the General Assembly at all contemplated arbitration at all when they were looking at this.
Well, I would definitely agree with that part of it, for sure. And we've not taken the more aggressive position, which is that the court review provision is completely inapplicable. Of course, that gets to the...
You're just, okay, so I just move this along. The only question before us, then, is whether the Superior Court erred in suggesting that an arbitrator can review an SLC determination.
That is correct.
You're not saying that the Superior Court erred by allowing the derivative action to continue in the arbitration, just that they said, and the arbitrator has the jurisdiction to override the SLC determination.
That is correct.
Okay.
Yes, that is correct. And actually, Justice Brobson, that brings up a really important point that I think needs to be emphasized in this case, because there's been a degree of confusion. This confusion was manifest in the Superior Court opinion. It's been perpetuated by the Son in his briefing before the court. This is not a derivative case. The Son has made derivative demands of the entities. He has said to the entities, we want to bring derivative claims, or you can bring derivative claims. The Superior Court blended the concepts together and assumed that an SLC review and a derivative action are the same thing.
Yeah,
they're not.
They're two separate things, and this case has nothing to do with whether the derivative action should proceed in arbitration. It has to do with whether the preliminary SLC determination needs to be before a court.
That is absolutely correct, Chief Justice Todd. And that's actually gets to yet another point, which is there's been this accusation that the entities and the father are trying to write the arbitration clauses out of the partnership agreements. And the answer is no, we're not trying to do that. We readily concede that most, I would dare say, the overwhelming majority of the parties' disputes would go to arbitration. As a matter of fact, the Sun, in his brief on page 37, footnote 11, concedes there's an arbitration between the parties right now. So all we're saying is there is one small sliver of matters, and it's what I like to call the SLC way station. If you're going to try to check or see if an SLC process was appropriate, you have to just visit your local court of common pleas and have the trial judge say, was the SLC unbiased? Were they independent? Did they do a fair review? And if you check all of those boxes, then the common pleas court says, okay, the SLC process was fair and appropriate. I'm going to bless it, and then that's the end of the discussion.
And is that or would that, in your view, respond to the point they make on page 28 about the FAA?
So the FAA issue, I have about 6 responses to that. The first is this court didn't grant an FAA question. It wasn't asked.
Well, they're the appellee.
Well, but
how's that their burden?
Well, it's their burden because it was their. Well, even taking a further step back, it was their issue to preserve on appeal because they appealed to Superior Court. It's not in their 1925 statement. That's at 248 to 250 of the reproduced record.
We said a while back, I think it was in 2010, in a Novoselsky case, that, quote, a claim of state law preemption by federal law is of such fundamental importance that it may be considered for the first time on appeal, question mark.
Well,
end quote, no question mark. It's getting a little late.
Understandable. And also,
notwithstanding the interesting nature of the last case.
Understandable. And Justice Weck, you also wrote the Parksburg opinion, which also speaks about the FAA issues. My response to that is, number one, it wasn't granted. Number two, it's been waived. And then number three, there really is no FAA issue here because we're not, like I said before, we're not asserting that the ultimate dispute, if it were to occur, could not be arbitrated. So if there were to be a derivative claim and were it to be adjudicated, we would concede that that can be arbitrated, in which case you are vindicating the FAA's.
Yeah, I thought that would be your point there. I just wonder whether that would be seen if Justice Scalia were still around, whether he would, and it went up to SCOTUS, whether he would just find that too cute, given what he said in Concepcion. Whether that slice there works from SCOTUS's perspective, but in any event.
Well, Justice Wecht, I've been accused of many things. Cute is not one of them. But in any event, even assuming there is an FAA question, and again, there really is not because the FAA's policy of arbitration would be vindicated here. Even if I dare say that might start to let the question of improvidently granted creep into the court's mind, whether this court should decide this case. I would say even putting aside everything else, and even if there is some FAA issue lurking in the background, this is but one provision within Section 8615. And if the court were to not confront the statutory misinterpretation here head on, it would leave on the books a precedential Superior Court opinion that could then be applied to the other 18 parts of 8615, let alone at least three other statutory enactments that use this same may not vary construct. So the General Partnership Act, the LLC Act, and the Statutory Arbitration Act all use the same may not vary construct. And the Superior Court here basically wrote that out of the statute.
I think you've made it clear, and I'm pretty sure we are all clear on that. So maybe move on to the next point.
Sure, absolutely. I would just emphasize to the court, this court and the Superior Court have already actually recognized the mandatory nature of the may not vary construct in 8615 in the Hanaway case and in the Ratner case. So Hanaway involved, the court may remember, the common law duty of good faith and fair dealing. Did that exist under a previous version of the LPA? That may not vary language came up in that case, and I think all the members of the court, even though there was a dissent on the question of the existence of the common law duty, there was a widespread recognition about the mandatory nature of that language. And not for nothing, the Superior Court panel here didn't even mention this court's Hanaway decision, which we, of course, view as problematic. It's always an issue when you're not following the court above you. And then the court also didn't follow its own Ratner opinion, which it was only decided a couple of years before. And in Ratner, which was an opinion by Judge Pellegrini, that was a question about the statutory wind-up provision, which is found in subsection 16 of 8615. And there, Judge Pellegrini's opinion for the Superior Court said a partnership provision that tried to alter the statutory wind-up was inoperative. So in many ways, this case really devolves to a very basic point, and we cited this court's decision in the American meat processors case for this proposition, that parties can't agree to something that's prohibited by a statute. And that's really all this case comes down to. There's a statute on the books that says if you're going to challenge what an SLC has done, you can only go to the local court of common pleas for a court review, which, by the way, features appellate review. So if there's a problem with how the trial court handles the court review, it can go to the Superior Court and then ultimately to this court.
But that's not a bar. And I go a step further. I think the statute means you can only do it by commencing your derivative action in the common pleas court and then maintaining it for purposes of challenging the SLC's determination. Put that back. Here we're also dealing with, to me, the key question is the jurisdiction of the arbitrators. That seems to me to be the issue. And the Superior Court said that the jurisdiction of the arbitrators in this case extends to reviewing the SLC's determination. So if I were to conclude in this case that the Superior Court was correct for allowing the arbitration to go forward because the arbitrator, there's a general arbitration clause for all disputes, but the portion of the grievance here, the portion of the arbitration complaint addressed to challenging the SLC determination, the arbitrator lacks jurisdiction over that. Why would I, and that's a carve-out. Probably means you win in front of the arbitrators if the arbitrators follow the law, because you can't bring a derivative action in the absence of a favorable SLC determination. But at least preserves the jurisdiction of the arbitrator to decide that while preserving the jurisdiction of the court over review of SLC determinations.
Justice Brobson, that gets to what you might call the cause of action argument that the Superior Court generated. We did not argue that. We didn't argue this procedure versus substance. All we argued, this procedure versus substance question, because I would agree under basic arbitration principles, there are some matters that are what you might call threshold issues that could go to the arbitrator and within the arbitrator's jurisdiction. But here the statute doesn't make that distinction. It says flat out, without a qualification for procedure or substance or however you might characterize that issue or that sort of granular component of the dispute, it says flat out, anything having to do with a challenge to an SLC has to go to common pleas court. And so that's the...
Well, I'm giving you that. I'm saying, see, even under the derivative cause of derivative statute, 8692, is it?
92 is.
Which sets forth all the prerequisites to maintain an action. That doesn't stop somebody from commencing a derivative action. They would commence it. So, for example, they could have an adverse SLC determination. They could go to the Court of Common Pleas, and they could say, I'm bringing my derivative action. The defendant would come in and say, oh, no, there's this adverse SLC determination, and you have to dismiss this. Wouldn't that happen in arbitration? They get an adverse SLC determination. They go to the arbitrator. They file their derivative action, and you go into the arbitrator and say, whoa, 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 whoa. They can't maintain this under the statute because they don't meet the prerequisites, one of which is a favorable SLC determination. And, oh, by the way, the common pleas courts have exclusive jurisdiction over overturning that. So you got to dismiss their derivative action. Why shouldn't it work that way?
Well, it could. I guess if the Sun were to, after the SLC, instead of going to, well, that's actually more or less what the Sun did here. The Sun basically commenced the AAA proceeding. Right. And so that's why we went to common pleas court, because we said that he's in the wrong place. He's got to be in common pleas court.
And you're challenging the jurisdiction of the arbitrator to rule on the SLC issue. Right. So you win, hypothetically, you win. That gets, because the arbitration complaint filed extends to more than just a challenge of the SLC determination. That's part of it, but it's not all of it.
Right.
So if this is a question of the arbitrator's jurisdiction to decide, and the arbitrator does not have, under your theory, jurisdiction to decide whether the SLC was correct or not.
That is correct. That's exclusively within the Court of Common Pleas, because that's the way the statute is written. And I would actually, I'd like to back up just a couple of steps just to clarify. So 8692, which is the statute that deals with derivative actions, it's sort of these statutes, they're written in like an organizational tree. It's almost like a choose-your-own-adventure novel, if you will. And so if under 8692, the first choice is that the partnership could make this decision for itself without help. It doesn't need to go to an SLC. And it's, I think, 8692B says that if the partnership chooses to decide for itself, it has two options. It can choose to say, we're not going to allow a derivative action. We've looked at it. We don't want it. End of story, end of discussion. And then option number two is, you know what? We're going to let you, plaintiff, bring this derivative action. So I struggle with sort of responding to the question about what the arbitrator is going to be doing, because it sort of seems that if the partnership does it for itself, that's kind of the end of the discussion, more or less. We're on option B, or path B, which is the SLC path. And our point about this substance versus procedure distinction is that it's sort of like we've got sidetracked, because we never made this procedure versus substance argument. In our mind, this is just a plain language analysis. It's what do the plain words of the statute say? And it says may not vary. By the way, it doesn't say may not vary a part of the SLC mechanism. It says may not vary a word of 8694. If you're going to invoke this SLC mechanism, you have to take it whole hog. You can't change it at all. And so that's been our argument. So the procedure versus substance argument to us is a non-issue, because the statute doesn't speak in those terms.
Well, and if the SLC question goes to the Court of Common Pleas and there's disagreement over it, would it go through the regular state appellate process?
That's exactly right. And that's actually one extremely fundamental point that we tried to make in our briefing, and we think that the Superior Court missed, because the Superior Court looked at this as, oh, well, we have a policy favoring arbitration, and so shouldn't we just rule on that? And that's more or less guided the court's analysis, which led it to completely miss the existence of 18. It didn't even mention 18, which is our whole argument, isn't even in the opinion. And the practical reality of that is, Chief Justice Todd, you're right, that if this goes through a court review and Court of Common Pleas, then you have available appellate review if that process goes off the rails. Sometimes it happens, and that's why we have the Superior Court to do error correction, and that's why we have this court to ultimately guide all courts as to what the law should be. If this is arbitrable, because most every partnership agreement has an arbitration clause, that means that the Superior Court's opinion effectively deletes the court review out of the process, and then just everything goes to arbitration and nothing goes to Common Pleas Court.
Right. I think we understand your argument. Let me ask if any of my colleagues have questions. Do you want to sum up, sir?
For these reasons, we just ask the court to reverse the Superior Court and reinstate the trial court decision.
Best summary of the day.
All right.
Thank you. Mr. Piermate, you have to tell me if I'm pronouncing your name correctly.
Piermate, that's correct.
I did it, okay.
Thank you. Good afternoon, Justices. May it please the Court, my name is Dean Piermate. I am here for the limited partner, James W. Miller. I think there's a key question or comment raised by Justice Weck earlier, which is, are we being too cute trying to split this down into an SLC review and then an arbitrator looking at the actual derivative claims? I think we are. This is a derivative claim. If you look at section 8615C17, the one that talks about you cannot unreasonably restrict a partner's right to bring an action. If you look at that section, that talks about, in the comments, you can bring an action in arbitration, a derivative action in arbitration. If you take that then and look at 8692, derivative actions, 8692A3 is a derivative action can be maintained for purposes of review under 8694F, which is the section we're talking about here today. So you're looking at these sections as a whole, you get a better picture, a better understanding that the SLC review process is a derivative action, and it can be done in arbitration. The legislature provided for that. So to say we can somehow split out the court to look at just the SLC section and then have it a two-step process where it then goes to arbitration is not only inefficient, contrary to what the parties wanted. They wanted arbitration. They wanted a streamlined process. They wanted something that was confidential. None of those things are going to exist. It totally frustrates the parties' intent, and I think it goes against the legislature's intent that derivative actions, i.e. SLC reviews, can be arbitrated.
Well, that's a little bit of a problem because derivative actions are not i.e. SLC reviews. They are different things. And there's no reason, if we decide that the SLC question goes to the Common Pleas Court, there's no reason that the derivative action can't be pursued as it was intended under arbitration.
I understand, but with all due respect, that's not what 8692A3 defines a derivative action as. It defines it as an SLC review.
No, no, it does not. It
So-
says is maintained for the limited purpose of seeking court review
Yes.
under 8694F, for the limited purpose of, which means it is not the derivative action. It is for the limited purpose of seeking court review of the SLC determination,
I understand.
which takes you back to the court.
I understand, Justice, but it does start off in A. You may maintain the derivative action for the limited purpose of seeking SLC review.
Yeah, but that doesn't transform a SLC, that doesn't transform, this is, again, the way the statute was written and modified. I do really feel like the General Assembly wasn't thinking about arbitration because the whole provision on SLC review is built around this idea, and the language you just read, built around the idea that the derivative action will only ever be brought in a court of common pleas where there's an SLC determination at issue. It sort of forces you when you get even though you have a right to arbitrate, it's sort of, statutory language sort of forces you to bring your derivative action in the common pleas court and then maintain it only for purposes of challenging the SLC determination, because if you win that, the derivative action goes forward. You don't have to file a new separate derivative action. Are you following me mechanically?
I do.
And I think your problem really is not that you can't bring a derivative action in arbitration, but because you didn't file a derivative action in common pleas court, you can't challenge the SLC determination through that section because you didn't bring your derivative action in common pleas court. You brought it in arbitration.
Well, how would you ever challenge it then?
I agree with you. You can't challenge it in arbitration. I just don't think you can challenge. I mean, the way the statute is written, it forces you to file your derivative action in common pleas court and get an SLC determination, because if you file it in arbitration, you can't, at least what the argument is, can't challenge. An arbitrator doesn't have jurisdiction to review an SLC determination.
I understand, Justin Probson, but I would say that that then runs afoul of your preemption issues, which says you have a right to arbitrate. You have a right to arbitrate your derivative action in an arbitration setting. You don't have to be forced to go to court. So, I mean, this court's adopted that in the extended care case. The U.S. court's adopted that. And I think that is all consistent with the comments you see riddled throughout the Limited Partnership Act, where they define court, or the phrase court shall, or the court must. Each of these occasions, if it's not in the comments, our courts have consistently said you can pursue arbitration, which is consistent with our broad policy of we encourage arbitration.
You're saying in that regard that even if one were to disagree with aspects of the Commonwealth Court's opinion, this still is a categorical state interference with arbitration and federally preempted.
I am. I think if you say you can only file in court, but the parties, and in this particular case, the partnership wrote this language. This is their language, their desire, and they've selected arbitration, and you say, hey, you can't pursue arbitration because you have a limited right or you have a limited option subsequently. I don't think that's consistent with what was intended, that derivative actions can be arbitrated.
But they can be arbitrated, and this will be arbitrated if it's, depending on what happens with the underlying challenge to the SLC determination, which I understand must be in common pleas court as a preliminary matter to proceeding with the derivative action in arbitration. So tell me why I'm wrong.
I won't say you're wrong. I'll just say I share a difference of opinion that there's no language set forth in any of the sections of the Limited Partnership Act that says you cannot arbitrate something. Just to contrary, as I highlighted earlier, you can arbitrate derivative actions and other actions. I believe to look at the SLC decision, there's a standard to be applied. That standard can be applied by an arbitrator or a panel of arbitrations, whatever the parties to choose. There's no assault on the business judgment rule because you go into arbitration. Just to contrary, the reality is arbitrators oftentimes are specialized in certain areas. So that's protected. That element's protected. As far as saying this is not an action, I think that runs afoul of 8692A3. I think the language in that section says you can maintain a derivative action for purposes of reviewing under 8694F. That's what we're doing. For the limited purpose of reviewing the SLC determination. Exactly, but it doesn't make it any less of an action. And an action has to have availability of arbitration, or I think it runs afoul of the preemption.
Well, explain that to me, because I'm a little bit confused by the breadth of your argument. You're suggesting that although the Limited Partnership Act defines court as a court of common pleas, the legislature is unable to direct review of the committee's decision to the Court of Common Pleas.
Agreed.
Court of Common Pleas, you're saying, must be read to arbitrators, or court means any adjudicative body. Court does not mean Court of Common Pleas.
Within the section of, within the context of what we're talking about, I believe it means you have to allow the parties to avail themselves to the arbitration option, as they've opted to do in this particular case. So to cut that course of action off and say, no, this particular derivative action, i.e. the limited review of 8694F, that limited review, you have no court, you have no arbitration.
It's not cutting off the derivative action. And I'm not sure I agree with Justice Robson's interpretation of the entirety of 96, but all that this does is take the preliminary decision of the committee to the Court of Common Pleas to apply the statutory business judgment rule analysis. Thumbs up, thumbs down.
Sure, but
that's not the derivative action.
Okay, let's step back then. Let's step back and look at it. We're in the SLC setting. The SLC makes a determination. Here's our determination. Here's our report. How do I get that reviewed? I have to file an action. I have to file an action in the Court of Common Pleas. That's an action.
Well, but the General Assembly said that. I mean, in other words, it's not. Well, putting the FA unless you get Marmot or Concepcion, preemption FAA to cover you, then isn't the default the interplay of 8615 and 8694? Hasn't the General Assembly said you may not vary these provisions, and then you're forced into arguing that the court means the arbitrator, which seems a tenuous argument, unless you're deeming it a euphemism or something.
Justice White, that's exactly what the court said. That's exactly what the legislature said in Section 8615C15, which talks about dissolution. Okay, it sets forth the requirements. It says you may not vary. You may not vary the requirements set forth in 8681, which sets forth your requirements as to when a disillusionment can occur. A6 says when there's a court order granting disillusionment. Okay, so you've got a very specific and similar language. You may not vary these terms unless, and here's one of the situations, how court orders it. That same section, 8681, goes on to define court the same way this section does, Section 102. And
Okay,
it says-
Mr. Piermatti, we may not all be on the same page, but I'm confident we all understand both arguments, so I'd like to ask you to sum up.
Absolutely. I think you take our approach is you look at the policy that's to be favored by this Commonwealth, and that is we favor strongly arbitration. The parties chose arbitration in this particular case. The statute that we're talking about in various sections all are consistent with, if you use the word court, it doesn't mean court, you can arbitrate. And I think that's all consistent with the preemption law. So for those reasons, we are requesting the appeal be dismissed and you uphold the Superior Court.
May I just ask him one question? I hate to prolong this for you, sir, but
That's fine.
You're enjoying.
I
you're
actually
enjoying
do.
this.
Yeah, why not? It's
Fascinating
2:30. This partnership had the ability to maintain arbitration throughout every aspect of any dispute, including derivative actions, by providing in the agreement that they were not going to use a special litigation committee. This partnership made the decision that in this circumstance, they were not opting to arbitrate. They were opting instead to keep the provisions of the Limited Partnership Act in place as to special litigation committees. It was the partnership's option from the outset to opt out of arbitration in this particular circumstance by not opting out of the special litigation committee process. And I see no federal preemption issues in that circumstance. This was a decision that was made by the partnership at the time it entered into its agreement.
I respectfully disagree with that characterization of what the partnership did. I think in this particular case, they strongly want arbitration. They don't want to see the courts, no offense. They don't want to see the court's appeals. They've made that very clear in their agreement. So I think
if they actually intended that across the board, they would have said, and we are opting out of the utilization of a special litigation committee. We are not going to court for any purpose at any time. This partnership didn't do that. They could have, but they didn't.
Unless there was an understanding that to appeal or to review that SLC decision, there has to be an action filed. We know that action has to go to arbitration, just like the current Books and Records action went to.
Not unless you opt out of the special litigation committee provisions of the Limited Partnership Act.
I understand.
Okay.
Okay, thank you, Mr. Piermatti.
Thank you.
Thank you both, well argued. I'd like to extend the court's thanks to Mr. Shovlin and Mr. Evans, our court security, along with the Philadelphia Sheriff's deputies. Thank you for looking after us, as well as the Philadelphia Police Department. We greatly appreciate it. And also thank you to our pathonetary, Ms. Gorman, and to our court crier, Mr. Minner. Mr. Minner, you may adjourn court.